the same time, I think it's important to acknowledge, how the things have evolved in India, and how it has matured as a jurisdiction for arbitration. And even from SIAC standpoint, of course, India remains our the key users. The main users, the foreign users are from India, the top foreign users, and India is a very, very important jurisdiction for SIAC. And I think over the last few years, not just from the legislative standpoint, where there have been strong efforts that have been made to bring in line and to promote overall the way arbitration is looked at, even the way institutional arbitration is being promoted all across the board. I think even the judiciary has really stood up, in terms of making, I think, greater efforts to be able to strengthen India's position in institutional arbitration. And of course, the latest example remains, how the emergency arbitrators have been, been sort of affirmed in the Indian jurisprudence, even without a specific legislative mandate on their account. So of course, there's a lot that we can talk about which needs to be done, but I must acknowledge, and I must say that I feel extremely happy that India as a jurisdiction is growing so strong, and probably by the next conference that we have in person, we would have come 10 steps ahead, in this journey. But at the same time, there are some learnings. I think I was trying to compare the Singapore Arbitration Act and the Indian Arbitration Act, and to understand what is it under their system in their laws that have been specifically been put to support the institutional arbitration, and to what extent can we in our Indian law look to maybe get some sort of inspiration, on tweaking some contours of our act that will facilitate institutional arbitration even further. So of course we did start with having, where institutions would start appointing the arbitrators, which is also the case in Singapore. There's also what taxation of costs, the powers that have been given to the institution under the Singapore framework, maybe something on those lines that we can look forward in the future under the Indian Arbitration Act. We can also look on some arbitrability of certain maybe IP related rights, have specific legislative, to have more prominent legislators coming out of that as well. So there are a number of factors that I thought we can consider in terms of looking at the improvements that we can make in our current system, particularly from the legislative side, to introduce those sort of amendments that will support and protect the institutional arbitration. So, and another point would be, of course, there have been a lot of discussions about the institutional arbitration in India, and all institutions are sort of working together to raise those awareness and also clarify certain myths that are existing surrounding institutional arbitration. So when we speak to the users, in India, there's some which of course believe that maybe institutional arbitration is more expensive and therefore resort to ad hoc arbitration. So I think that needs to, of course, continue to work on those lines to help users understand, what is the value add of an institution? How does the dispute resolution mechanism change with an entry of an institution which is overlooking the entire process? But at the same time, I think even at the government level, maybe if we see more efforts from the government to use, maybe stand to trailblaze, to use institutional arbitration in government contracts, I think that would stand as a good example for others to follow and to adopt institutional arbitration in their contracts and clauses. And I think the more number of cases that we will see with institutional arbitration, standing to really reaffirm the value that an institution brings along, the more likelihood of strengthening institutional arbitration in India. And I think that itself will have so many ramifications in terms of where the resources are being directed, how the dispute resolution landscape is going to change in India. So, these are just opening thoughts. And of course, we will all discuss this in detail during the session today, but just my initial thoughts on this.
Very good. Thank you. Thank you very much. I like one point is that your start, you have not looked at LCIA failure as a real institutional failure in India. It's just a matter of timing. And that immediately took me back to Pepsi and Coca-Cola. When Pepsi was coming to India, it has to go through so many hoops. And when Coca-Cola came, it was just a red carpet welcome. So the timing is important. So maybe we should encourage LCIA to come back if they want. But yes, it's still the issue. One issue is that the India, after like from 1996, ever since India has adopted arbitration law based on model law, we have not seen a flagship Indian arbitration center where from the outside we can say this is our center. So we will see that how we can achieve that. So in this regard, next I would like to ask Iram, because your center has been in India operating for a long time, IIM. What do you see your center as? You see any problem or your operation, your experience with that center, and what we can learn from your experience to move forward?
Thank you so much, Dr. Rajesh, and thank you so much for all the co-panelists. So before I begin, I would like to say that ADR and IT has a great connection in terms of progress. So if you see the IT, that profession has come, so in initial stages, like initial years, it was very slow. Then it took up its pace. And similarly, if you say the ADR, the entire ADR, it's not about the arbitration, it's the entire ADR. It was very slow initially. And the first 10 years was very slow. And after that, 5 years, I must say very fast. And 5 years, last 5 years are super fast. So in terms of IIM, if I say the IIM is there since 2001, and now it's been 20 years of this institution. And I heard from my senior that how much effort he has put in to bring this institution. And at that time, only ICO was there and IIM was there. So people were not aware about even ad hoc arbitration well and how to create the awareness about the institution. So it was very, very difficult because, see, there was lot of interference by the court and highly judicial, interference, and the judicial retired judges culture was there to be appointed as an arbitrator. So that is how the people used to be, having a nexus with those judges and having a nexus with among themselves, and they used to get appointed, in a year, must say 25 cases for the same judge. But now after 2015 amendment, the things are changed and you cannot have 3 cases in the same time for the 3 years. So things have changed after the amendment. But I would like to say that India, we have a lot of disputes. We have a lot of disputes and we are the great exporter of our dispute. We were not having a robust mechanism. We were not having, the culture of institution, and that is why we lack. And I feel that there are, see, in the course of discussion, I'll be pointing out many, improvement in the ecosystem, which can create, an awareness and all. See, we have to work as a single unit. If we talk about the institution, the entire burden should not be on the shoulder of the institution. If we talk about the lawyers or the practitioners or the judiciary, then also the entire burden should not be on their shoulder. If I say the academicians, entire burden should not be on their shoulder. We have to carry every part, our things on our shoulder, and we have to work as a single unit. The judiciary should support the institution, and institution should support the academician, and we should have more academician on the panels. So that is how the awareness should be from the ground level. And if we talk about the ADR practices and all, see, no professionalism was attached. Glamour, yes, glamour was there, but no professionalism. We used to have the practice only in the late evening after 4 o'clock, and we used to sit and we used to have a coffee and all, and we used to complete our arbitration. But now by the institution, see, like for me, I have completely shifted my entire practice to the 9 to, no time limit for the ADR and the arbitration, completely into blended with the ADR practice, and no time for me to rest with this. And this pandemic has come up with a great booster. And due to that, I think that has not been mentioned about the 𝗵𝗶, the Asia Pacific Center for Arbitration and Mediation. That has come up in the pandemic only, and we have inaugurated in the pandemic. And I'm the executive director of Asia Pacific Center, and that has created history because IIM is the founder member of it, and it has created history because, as I said, India, we are exporter of our disputes, and just because we were not having a mechanism. See, we have seen that lot of problems arising, that sometimes accreditation problems, sometimes professionalism problems, sometimes we were not having good panelists, sometimes we don't have a good arbitrator pool, sometimes lack of rules. So we keep on surveying on this, and we come up that we should have a mechanism which will be as an international as well, and also have a domestic branches there. So that is how we come up with the 𝗵𝗶, and it is the first time the history is created in the ADR regime and in the ADR arena. So I'll tell that the Asia Pacific Center is an international ADR center formed jointly by approximately 10 arbitration and mediation centers from Asia Pacific countries, having 𝗵𝗶 centers all over these countries. And it caters the requirement of international and the cross-border disputes and help the business community to resolve their international and commercial business disputes by mediation and arbitration. The benefit is under the single mediation and arbitration rules with a uniform fee structure, and there is absolutely no hassles in appointment and subscribing of the different rules. And the countries, if you look what all the countries and the institutions are there, the best institution of their own country, like IIM is there, Malaysian Mediation Center is there, PMN Indonesia, and Hong Kong International Mediation Center, Hong Kong Institutional Arbitrators, Thailand Arbitration Center, Australasian Dispute Resolution Center, Nepal, and the Korea. So what I'm trying to say here, that what we were lacking, what I felt since 2001, is that we were not having that culture. But now, if I look back 5 years back, if I calculated 10 years, was literally very slow, 5 years so fast, and 5 years super fast. And that super fast had inculcated, or we imbibed the culture of institutional arbitration. And if I say now, the court are also supporting. Many courts are supporting, and I have seen the judgments also. And now the parties are coming directly to the IIM, and and they're asking that whether you are doing arbitration in the UNCITRAL model, because they want to invoke international arbitrations as well. So that is how we are creating awareness, and by providing either accreditations and all. And now I could see that. If I say Mr. Tejas, he was the one who taught me about the arbitration. So he is my teacher also. So I could see that only few people, a handful of people, were there in the arbitration earlier. And if we go in any conferences, so those were the people. So now awareness has been created by them, and they are the leaders. And now many people are following, and they are coming into, and we are following it. And I could see that now the other students, they are following us. So that is how we are developing as a hub. That is the hub. If we create a hub awareness among the students, among the users, among the institution, among the judiciary, that will create, that will change the complete shift. That will bring a change. That's what I'm feeling, and we are into trance, and could see more in next 2 years, I guess.
Very good. Thank you very much. Your story has told us that to be successful in India as an institution, you have to have resilience. Just stand there and stand and deliver over there. So and it's very good to see that IIM has been kind of like a catalyst for formation of Asia Pacific Arbitration and Mediation Center. Very good. So some positive outlook. So it's not total failure, which we were discussing about. Is there some positive things are there? At this point, Smriti, may I bring you in to discuss about your experience with ABA and like what we can learn from there to implement in India?
Thank you, Dr. Sharma. Good morning to everybody, and I'd like to thank the organizers and congratulate them for putting together this event. My colleagues who spoke before me, both Shweta and Iram, seem to have succinctly summed up a lot of the issues that we're facing, but I'd just like to quickly add my 2 cents again, with all due respect to the organizers, I honestly believe the topic today should be challenges faced by arbitral institutions and not setbacks. For I believe you can change challenges into opportunities, like Dr. Sharma pointed out. The reason I bring this up again is, of course, I believe a very key point of making India a hub, as was discussed in the beginning, is that apart from changing logistics and everything else, the narrative and the optics have to change too. Both people in India and both people outside India need to start acknowledging and recognizing India as a viable venue, and this is a venue, center, seat, etc. And this starts with changing the optics at both the domestic and international level. Having said that, I sincerely believe dispute resolution is not a one-size-fits-all mechanism. Despite being in an institution, and I'm hoping I don't get into trouble for saying this, jokes apart, I do not believe institutional arbitration is the answer to every dispute. However, institutional arbitration does provide a much-needed structure to create the ecosystem that all of us here seem to have the common objective that we're working towards. It's one of my favorite quotes, and I often say this, is what Justice Sundaresh Menon, the Singapore Chief Justice, said. He said the term ADR has since evolved to now mean appropriate dispute resolution. It's no longer alternative dispute resolution. And I think this is the focus that all of us should adopt. And this is a much needed focus, especially and will be a recurring theme between this and also the next topic, which we'll talk about, is the harmonizer, and to bring together developed economies, both in terms of finance and in terms of ADR. This is an approach that will help us. And I speak from the experience of AAA, the American Arbitration Association, and ICDR shares a very similar story to what SIAC said. It's been around for about 95 years. It's focused on innovation. For example, we invented the emergency arbitration, which is so successful across the world now. And what we've seen is consistently for the past 5 years, for example, of the 250, 300 international cases we get from Asia, India has topped the chart consistently. So clearly, there's no dearth of people using arbitration in India. So the focus obviously has to be shifted towards how does India, like Iram just pointed out, stop being just an exporter and start also using other facets. And I am looking forward to this discussion amongst us to also gain insight on what we can do as an institution. But I will add that the timing right now is very appropriate, because I believe the pandemic has made has become the great equalizer of arbitration, because suddenly you find recalcitrant lawyers using technology, people from all over the world using online arbitrations, online mediations, which 2 years ago, even if you were offering it to them for free, most lawyers were not willing to, or most lawyers, parties, and businesses were not willing to do that. And now we see that it's possible. A different set of challenges arise. So yeah, I know this is opening remarks, so I'm just going to make a few quick points on what I think we can look at in terms of setbacks and how to take this discussion forward. One, of course, is what can we do as institutions as well to contribute to this domestic ecosystem? Because for India to become a successful seed, the law is there. We're seeing that judiciary is becoming friendlier. The optics have to change, but also arbitration has to become mainstream. It should no longer be about, oh, do you have a dispute? Let's take it somewhere. Where are we taking it? Are we taking it to New York? How can we do it is to focus on some of the key issues that businesses and stakeholders use, that is costs. And right now we can talk about use of technology to make costs more easier. Let's talk about how we can build capacity to create not just more disputes in India, but more arbitrators, more seats, and more wholesome, more wholesome usage of this entire ecosystem. There should, of course, be a focus on settlement. And honestly, I think we should look way beyond just talking about arbitration and mediation, since this common adage, cash is king, is going to become way more relevant in a post-pandemic phase, where so many businesses are struggling to make ends meet, and settlement might just become a more feasible option. What else can institutions do? For me, I think one of the things we can talk about today is how do we help bridge the gap between businesses, chambers, lawyers, and dispute resolution practitioners, because that huge bridge oftentimes ends up in, say, not using dispute resolution or being uncomfortable with the use of dispute resolution. How can institutions use technology? One of the things that we at the ICDR do, for example, is although we set up the Asia Case Management Center in Singapore to cater to India, that's more for time zone. We've tried to digitize almost all of the case management system even prior to a pandemic. We have, for example, a clause builder which a common man can access online to create their own dispute resolution clause, etc. So these are some of the ways we can address these challenges. I look forward to a more interesting and stimulating discussion. My closing remark, of course, once again resonates what both Iram and Shweta said. The pie in India and the pie elsewhere for dispute resolution is big enough for everybody, and it's constantly expanding. So our job should be working more towards collaboration, whether we're multiple units or a single institution. It's about a cohesive action plan, and once you have that cohesiveness, I think the rest will just follow suit. Anyway, thank you for your patience, and I look forward to speaking to you all.
Well, thank you very much for recognizing the India's potential, what can be done, and validating what Iram was saying, that India is an exporter of dispute. And I'm thinking that if AAA has done 200 cases from India, that means minimum 200 arbitrators have missed their opportunity to act as an arbitrator, or maximum 600, we can say that, and a couple of emergency arbitrators, and many arbitration lawyers. All of these could have been done in somewhere in India, but it went to New York. So very good point in that one. Yes, bridging the gap is another interesting part, and how the lawyers, business, and the institution can bridge the gap. And that gives me a very good transition to move from the institution to practitioner side. And for that, I would like to invite first Mr. Tejas Karia to discuss from his perspective as a practitioner dealing with the institutions and your experience with them in terms of appointing arbitrator, managing arbitration or enforcement or anything. So what you can share, what you can tell us or tell everybody that what India should do, or basically what you should lead into that.
Thank you, Dr. Sharma, for that kind introduction, and good morning, everyone. It's always a pleasure to come and speak on this platform. So just to come straight to the point of institutional arbitrations, as we all know, arbitral institutions play a major role in terms of administering the arbitrations. We have seen in India, there is always a preference to ad hoc arbitration, and that is maybe for a couple of reasons. Is that there is a perception that the arbitral institutions are expensive, but in experience, what we have seen is that the structured approach and the kind of services we get in the institutional arbitration, overall the cost is much less, even though we have an additional cost of institutional administrative fees. But if you see in long term, and we have done that analysis, we have seen it is much cheaper than to do ad hoc arbitrations, because ad hoc arbitrations over a period of time with the number of hearings, because the administrative tasks which the institution can provide at much lesser cost are always done by the arbitrators in the ad hoc arbitration. So if you see the comparative analysis, we are spending more on the ad hoc arbitration. The other apprehensions people have who are the users is that the institutional arbitrations are not flexible. Whereas in practice, what we have seen is that even though you have the institutional rules, but with the involvement of the institution and the arbitral tribunal's intervention, they have enough flexibility to run the arbitration process in a guided manner. The most important aspect which we have seen in institutional arbitration is certainty in terms of the timelines and the cost, because many of the institutions have the cost calculator on their website. So you put the amount in dispute, you know exactly how much cost is going to have, and we have seen parties settling the dispute because they know exactly how much is going to cost, and it's not worth their time and money to fight the whole arbitration. The main other aspect which we see is the appointment of an arbitrators. Of course, in India, we have come a long way from 2015 amendments. I was part of both the committees of Law Commission and High-Powered Committee of Justice Sri Krishna. And we tried to promote institutional arbitration as far as possible. We need much more to be done by adding the definition of emergency arbitrator in our law, which is still pending, but it will be done soon, hopefully. And once we have that kind of recognition, we are reducing the intervention of the court in grant of interim relief, as well as in appointment of an arbitrators. If the parties fail, then the default mechanism should be institutional appointment, because many of the institutions have their own panel of arbitrators who are experts, who are available and are able to devote time to the entire process of arbitration. And when we get a request for appointment, we have to give our calendar for at least next 2 years to tell them that we are available, how many cases we are doing. And the aspect of avoiding conflict of interest, if there is any slightest of conflict which is likely to arise, the institution will take care of it. There is internal mechanism to deal with this aspect. I'm member of Court of Arbitration of SIAC, and I have worked very closely with Shweta and our colleagues to ensure that all these issues with regard to appointment, joinder, consolidation, all this is taken care of as the court level, and the tribunal is not even bothered about all these administrative aspects. Joinder and consolidation also helps a lot, because in an ad hoc arbitration, you don't have any provision in India to have a joinder of parties or consolidation of arbitrations. In some cases, Indian courts have appointed the same tribunal to avoid multiplicity of proceedings and to have consistency in findings. But if you have an institutional arbitration, and if there is a contract which has a multi-party contract or a multi-contract relationship, then joinder and consolidation makes it very easy for parties to save the cost to almost half, because the same tribunal will decide the dispute. They will have the same facts. Maybe the contract are different, but award can be passed separately, but you have a consistency in the whole approach of doing arbitration, evidence gathering, and examination of witnesses. Other services which institution also provide is fund holding, because many times we waste a lot of time as practitioners to remit the fees of arbitrators. We have to spend time in ensuring that whether we have given the tax deduction certificates, and arbitrators always come back and say, you have not paid the fees. The first thing we start with the hearing is, have you paid my fees? In ad hoc arbitration. And the aspect which we want to avoid is institutional arbitration. We have never bothered about that. We just pay the advances, they take care of the whole fund holding, and most of the time we get the refund. So that is also a good thing. Even if you win or lose, you get some refund at the end of the arbitration, because they have always kept that buffer with them to ensure that the arbitration fees don't exceed to a particular limit. So scrutiny of award is also been a very helpful. When I have sat as an arbitrator, I'll give one example, is that I sent a draft award for scrutiny. They don't change the award. The only thing they say is that, would you like to consider this? So the one example was that I awarded interest. So I got a footnote saying that, would you like to consider a compound interest or a simple interest? Of course, I missed out on that, but it's a major feedback, because if it is simple interest, I thought it was simple, but I never put it like that. So those are the things which help you a lot as an arbitrator, because there is a possibility to appoint a tribunal secretary. But the way we have the institutional support in terms of also ensuring that the timelines are met. So sometimes you miss the mail, or you are delayed in responding your mail by fixing a time. So you get a reminder from institutions saying that, hope you have seen your mail, and you would be fixing a date for hearing. So those are the things which really help in institutional arbitration, which we are really missing out. So we wear two different hats. When we are an ad hoc arbitration lawyer or an arbitrator, then you wear a different hat. An institution, we do it completely differently. Whereas there cannot be two kinds of arbitration. In one country, when you have one law, one set of rules, how are we doing two arbitrations completely differently, which we need to bridge that gap and move towards institutional arbitration more and more. That I think we can do by doing a couple of things. The one is that change the law more or tweak it to the extent that the emergency arbitrator is recognized. Of course, we have now Amazon versus Future judgment of Supreme Court, which is quite helpful. Whenever there is a seat of arbitration, emergency arbitrator award or order would be recognized as if it's an order passed by the arbitral tribunal. So that's a great development we have had recently. But if you have a statutory backing, that would help. Secondly, we should also have government contract having institutional arbitration, because major part of our arbitration is on the public-private partnership contracts, infrastructure contracts, where public sector undertakings and governments are party, and they prefer ad hoc arbitration, and with due respect, former judges of High Court and Supreme Court to be appointed. Whereas there is a large pool of arbitrators who are available in India. Now we have an arbitration bar. We have also formulated Indian Arbitration Forum, which is very similar to any other arbitration bar, and doing good activities on the promoting arbitration in the capacity building also. And Chartered Institute of Arbitrator in London, I'm director of India branch of CIR in India, and they are also doing excellent job of preparing arbitrators and giving accreditation to the arbitrator, because as and when the Arbitration Council of India will be formulated, there would be a major requirement to have a pool of arbitrators who can be recognized, pool of arbitral institutions who can be accredited by the Arbitration Council of India. And we don't have to wait for that, because in many cases, under Section 11 also, Supreme Court and High Court has delegated their power to have the arbitral institution appoint the arbitrator. And that question came up when we were discussing as part of the Law Commission, whether you are delegating a judicial power because to appoint an arbitrator. And we purposefully introduced Section 11(6)(b) in our Act to say that even though you are delegating a power to appointment to an arbitral institution, it will not be considered as a delegation of power of a judicial authority. So that now statute has been amended to give that ability to the arbitral institution to appoint arbitrator. And when we have seen that happening in number of cases, is the best of the arbitrators are chosen by the institutions as compared to the court under Section 11. So over a period of time, once 2019 amendments are notified, in any case institutions will appoint arbitrators. But we need to really promote the mindset to go for institutional arbitration given these benefits. And just a thought on LCIA. I was also part of working very closely with LCI India. I attended so many conferences. Adrian Vincently had the vision for India. But it was very unfortunate that the timing, as we all discussed some time back, it was a timing when they decided to exit and we amended our act. And if that would have been there, and now we see that number of cases are now being administered by LCIA London as per LCI India rules. So now they are having a double problem, because these are all the arbitral proceedings which had to originally come to LCI India, but now it's being administered from London. So they are incurring more cost because the cost in London is obviously higher than administration in India. That aside, we have now good ecosystem, ICC, CIAC, and all other institutions are doing very well in India. We have Indian institutions across India. We have more to come in near future. Technology is being used to a great advantage of the entire arbitration process. So I don't see there is any setback. It's only, I see a very, very bright future in terms of institutional arbitration in India. Thank you.
It's good to see that the word setback has really triggered everyone to discuss about that, how good the systems are. And Tejas, is a very one thing you said, ICC always says in international forum that if you throw peanuts, you only attract monkeys. So that's why they justify their fee, the highest fee, which like India can think in other ways. But it's very good to hear from you that all the bright side of it, and it's good to have the expert like you in the committee, which can help the government or the legislator to devise a law on which we can say that India is also following the international arbitration mechanism. Otherwise, for 10 years, we were really hiding our face in any international forum when they were asking question about how Supreme Court got it wrong. But anyway, it's very good. But one thing you said that you very rightly said that new centers will come. And that brings me to Mr. Rajdeep Chaudhary. You are a practitioner and you are also in panel with Hyderabad Arbitration Center, which I understand that is a very new one. So you can tell us from your experience as a practitioner and as an affiliated with the arbitration center, a new arbitration center, how did you manage to do that? And what is your views and future and aims and objective behind that?
Sure. Good morning, everyone. And thank you to the CADR and to the HAC for inviting me to participate. It's a pleasure to be part of such a high quality panel. I'm looking forward to engaging in a thought-provoking discussion, which will trigger critical thinking, I suppose, on issues that are capable of driving policy changes or changes in the law with regard to arbitration in India. I just want to take a step back and sort of set the scene these discussions. In successful centers of trade and commerce are also efficient centers for resolving disputes. A jurisdiction's ability to resolve disputes efficiently will always send the right signals to businesses. It will give stakeholders the confidence that a rule of law prevails in that jurisdiction. It will give them confidence that enforcement of contractual rights can be expected. So that is the overarching theme when an institution or jurisdiction gets into the issue of how to send the right signals to businesses. And all of us are members of this arbitration community that is cross-border. We are all stakeholders in this vehicle, which you might call is the India seat as an arbitral seat of choice. And it's important that we reflect critically and take stock of ways in which arbitration in India can be improved. Perhaps there are ways of course correction. There are ways of trying to recalibrate the system. I think the single biggest reform can be migrating as much as possible arbitrations into the institutional arbitration fold. We've all spoken, the other panelists have spoken about all the various reasons why institutional arbitration might be sort of a panacea. I completely subscribe to that hypothesis. I won't repeat the points that they have made. I just want to add that institution in arbitrations can be a method of choice because they act as gatekeepers to the arbitral process, right? I mean, they are critical. They are providing critical administrative and logistical support in the arbitral process. They often act to police and to regulate the process. They can sometimes scrutinize the award in order to minimize enforcement risk or other issues that may arise in the award. They also take care of the risks of a procedural breakdown. And all of these benefits of institutions are not present when you compare it to ad hoc arbitrations. I think Tejas has already highlighted why ad hoc arbitrations are often slower, less efficient, less predictable, less able to deal with issues as and when they arise in terms of administration, in terms of logistics. I think we're at a very critical stage now with arbitration in India because we've had a fair amount of reform in legislation. We've had a fair amount of case law development in the absence of legislation. Of course, we all know about various judgments in the last, say, 5-10 years, which have really improved arbitration law in India. We also know about the piecemeal amendments to the Principal Arbitration Act, which are taking care of many of the issues that were highlighted in the Justice Sri Krishna report from 2017. But I think what we need today is, if I can call it, reforms 2.0. And those reforms are not to do with a black letter law. They're not to do with arbitration case law necessarily, but they are to do with something that the Sri Krishna report itself had picked out. It said that amongst its many recommendations, it also said that we need a change in ADR culture. And that is the principal challenge today. And we all know that you cannot legislate for change in mindset. That has to come from within. self-regulation will only work to some extent, but I think it is self-regulation that is now required in order to take care of the low-hanging fruits as well as the high-hanging fruits, which are obstacles to making India an arbitral seat of choice. It's also to make India more attractive from an institution's point of view. I can just think of quickly, 4 or 5 ways in which we can tackle this issue, and of course we will deep dive as the session goes on. Conduct of proceedings. I think a lot of arbitral proceedings are not conducted in an efficient a way that is tailor-made to that dispute. We need a change of mindset. We need to improve diversity in the pool of arbitrators. And that diversity is good for many reasons. We can go into that at a later stage. We need to also embrace this concept of technology. I think COVID pandemic has really taught us that we can make virtual hearings work, subject to certain technological hardware and software challenges being overcome. It can work as a method for more efficient and cost-effective arbitral processes. We also need to be alert to what other jurisdictions are doing to encourage arbitration. One of them is third-party funding. Singapore and Hong Kong have gone ahead and have legislated in favor of it. India, of course, there's no legislation prohibiting it, but we don't have a clear-cut mandate from Parliament paving the way for third-party funding. There are multiple factors which go towards making a seat of choice. There is neutrality, there's rule of law, there is court support, state support. There's a quality of the arbitral bar. There's a quality of the arbitral, the pool of arbitrators. That's also critical. Ease of doing business. All of these things, all of these factors typically conspire, if you like, to create a seat which is of high quality. HKIAC and SIAC, they came into existence because of government support. Let's not forget that a critical, important fact. And they continue to thrive because they continue to be able to rely on ongoing progressive government and state support. Of course, their courts are fantastic. Our courts have now become, I think, equally fantastic. The interventionist mindset has gone away. There is a great acceptance of pro-arbitration in terms of how judges think about it. But there are odd occasions when there's a lack of uniformity amongst the high courts. I think in a federal country with so many high courts, with so many different centers of commerce and so many different high courts across the board, you may have some inconsistency, but I think that inconsistency is being ironed out over the years. And there's now a uniformity. But I suppose the biggest challenge are going to be those mindset or cultural challenges, which, again, the Sri Krishna report focused on. And for that, I think it's a lot more of a collective effort. It cannot be imposed from top down. It has to come from within. And I look forward to discussing further all the various ways in which we can make baby steps into making India a much better in a seat of choice, as well as making it just a better place for resolving disputes efficiently and cost effectively. Back to you, Dr. Sharma.
Thank you very much for sharing your thoughts. Change of mindset, the key point which you mentioned, and I'm sure the judges are changing their mindset, the lawyers will change, and clients will also start thinking about it. And maybe instead of exporting the disputes, we will all resolve it in India. That would be quite good. I see Anvo is not here. I will come back to him. So then, Satvik, I have to come back to you, or I have to come to you for the first time. I understand the Indian government has a report to envision that how to set up India as a hub of dispute resolution. A government report. I think it was from Niti Aayog. All. And if you are aware of that, or from your academic side involving in that, providing the legal assistance to the government department in developing the dispute resolution system or any other thing, you can tell us your view as an academic or as a user. How do you see in future India to develop as a hub of dispute center?
Thank you, Dr. Sharma, and good morning / good afternoon to everyone. I think It's funny that the quality of the panelists today is such a brilliant, there's such brilliant panelists that I have to go off script because everything which I thought to talk about has been talked about already. I wanted to talk about technology. I wanted to talk about the misconceptions and the myths surrounding institutional arbitration. I wanted to talk about trust building in institutional arbitration. I wanted to talk about the government support and the business support for arbitration. We've all been talked about. One thing which in my personal interaction with the arbitrators around the Delhi circle and the Bombay circle, I've realized one thing, which is not a critique, but it's just a fact that probably we need more sector specific expertise amongst the arbitrators. That's something which you might find in other international institutions of arbitration. Suppose we talk about technology. Now, on 26th November, I was a part of another panel discussion for the Constitutional Day in India, and there again we talked about technology. So the question did come to the fact that you might know the law around technology, you might know but a lot of lawyers and arbitrators might not be aware of the technology in itself. There was a gentleman who said that the client was involved in a dispute around cryptocurrencies and blockchain technology. Unfortunately, he himself couldn't understand, even the senior counsel couldn't understand the technology involved. Unless you don't understand that, how can you really give a robust legal advice to the client and take ahead with the proceedings? So I think if that's a difficulty which lawyers might be facing in the litigation side of things, I think it might also come up on the arbitration side of things as well. So maybe that could be an area which remains untapped, where we can have sector specific expertise amongst the arbitrators. And maybe it could be technology, maybe if it's a real estate dispute, and like the construction business, and probably if there is biotechnology, chemicals, like there are so many sectors in which disputes could be there, depending on the client, on your client. So that's one thing. Second thing which I wanted to mention is that so at our center, whenever we come out with whenever we advertise for positions, either for internships or for full-time jobs, we see a lot of students, a lot of young advocates and young professionals who have an inclination towards arbitration, or might have pursued their masters in arbitration, but they still end up working in under lawyers or probably in law firms and all. So maybe the institution, the arbitration centers in India might have to onboard them, the youngsters. Maybe they might also bring a new, again, like around technology. Maybe they understand technology better than we might. So maybe we can give that exposure to them, and that will help in building trust amongst the arbitrations. Because the myth around the fact that in India people think, or used to think, things have changed now, that institutional arbitration restricts the flexibility of the disputing parties. One of the examples is that uh, I was actually speaking to a chief financial officer of a company, and obviously, I mean, even if he was CFO, he said that we believe that by going in the direction of institutional arbitration, we are restricted to choose from that particular pool of arbitrators, and we don't want to lose that flexibility. That's why we rather prefer ad hoc arbitration, where we can have the flexibility. Now, my understanding is that the only way we can beat that, I not beat the system, but improve the narrative around that in favor of institutional arbitration, is by providing them, again, like sector specific expertise amongst the arbitrators, and to show them that maybe what you're thinking is not right. We have institutions which are robust, which have actually adopted probably a set of guidelines to choose and to make sure that there's a robust criteria for arbitrators to be selected in the pool. Maybe a code of ethics, maybe there are a lot of things to be learned from SIAC and Hong Kong specifically. So that's my second point. I won't go into the amendments to the Arbitration Act part, because we all know about it, and we have so many practitioners and so many arbitrators here. So I am actually, I would be the last person to talk about those things. But I wanted to mention something around the fact that we have I think it has already been said that we don't have to rely, and we should not and must not rely only on the centers and the arbitrators to drive the bus of institutional arbitration. The government definitely needs to do something about it. The businesses definitely needs to do something about it. See, government of India. I come from the government of India, so these are my personal comments. That's the caveat. But still, we know that the government of India is the biggest litigant in the largest litigant in the country, and it's been mentioned by the speakers before me. Why don't we have institutional arbitration as the first preference of dispute settlement in government contracts? That's first thing. But having said that, if you look at SIAC, 70%, I think this is 2017, 2016 figures, that more than 70% of disputes involve Indian parties. Where are the businesses? What are the businesses doing? We have Mumbai Center for Institutional Arbitration. We have Hyderabad. We have one Nani Palkiwala in Chennai as well. We have Delhi. So we have these circles where you have these centers for arbitration. Why are the businesses not adopting them? So onus equally lies on the government and the businesses as well to onboard institutional arbitration. Probably, I think, see, it's more difficult to begin. The initiation phase is the make or break phase, because it's again just like an attorney-client privilege. The entire game revolves around trust. The attorney should be trusted by the client, and the client should be trusted to be honest and very, very transparent with respect to from a lawyer's point of view. Same goes here. Maybe they trust arbitrators, not just the system, but the personnel in Singapore and not here. Why? We have to find reasons for that. Because it's not just about the system. We talked about technology. Pandemic has shown us that virtual hearings can happen even at the district court levels. Albeit I'm sitting in Delhi, so district courts are digital now, and other tier 2, tier 3 cities they're not. But the pandemic has shown us that onboarding technology is not very difficult actually. And institutional arbitration centers first USP used to be adoption of technology and providing the flexibility of virtual hearings, virtual arbitration proceedings. Now, I think that's something which cannot be one of the prime attractive elements of institutional arbitration. So probably we have to think on that line. And lastly, I think we need the businesses to be involved in promotional activities of the centers as well. Because the moment you realize that it's only the centers who are promoting themselves, it's a handicap. Obviously, like 𝗵𝘀 𝗖cie𝗹𝗹, who's from MCI, she's been doing a lot of promotional attempts, and she's been doing well. But then again, like, I've always talked to her and I've always asked her, you come from the Mumbai Circle. Mumbai Circle is a hub for mercantile business and all, right? So where are we with respect to onboarding the businesses? There is probably a lag, a vacuum when it comes to the seriousness of institutional arbitration amongst the businesses. The businesses might be very happy to be seen as pro-institutional arbitration, but are they really serious about institutional arbitration? That's something which we have to tap into. I went off script right now because my script is actually in the bin, because the brilliant panelists before me have already covered everything. I mean, Mr. Karia was member of the Shri Krishna committee, so obviously like 90% of my task was done by him, so thank you so much for that. And Rajdeep also mentioned about the technology part of it. So yeah, it was interesting to hear you all, and these were just the opening remarks. Let's see where the discussion takes shape. Dr. Rajesh, it's on you.
Thank you, 𝗧𝗵𝗲. It's good that you throw away your script, talk from your heart, and talk from the young upcoming arbitrator what you want to see in India to happen. And the job of Mr. Karia and Rajdeep and all to make it happen, because they are at the right place to do that. So it's good to have that vision and like a dream. then we can achieve. Now, where is 𝗂𝗵𝗲? Have we lost him?
No, I'm here. I'm here. I'm here, Dr. Sharma.
Oh, okay, good. 𝗂𝗵𝗲 is young, but he's very anubhavi, and he has very anubhav of dealing with many centers and the clients. So 𝗂𝗵𝗲, from your perspective as a young user and a lawyer in this field in India, what is your experience with dealing with the Indian institutions and the external and the foreign institutions with regard to managing of or appointment of arbitrator, managing with the center, managing with the clients? What is your experience? Can you tell us, and how we can translate that into the development of Indian scene or Indian arbitration scene?
Thank you, Dr. Sharma, and thank you for classifying me as young. It's good to hear on a Sunday morning. And with that, I mean, when I had just begun my career and I had the opportunity to attend a session in the Bangalore Arbitration Center on a weekend, and being extremely new to the profession, I had a lot of questions, and I think that session was presided by Justice 𝗬𝗏 who was a judge in the Karnataka High Court. So I had asked him similar questions at that point of time about the huge gap in arbitral institutes in India and abroad, and what we can do to fix it, and so on and so forth. And I was absolutely unaware about the developments of, let's say, the Bangalore Arbitration Center and so on and so forth at that point of time. In front of a very populated crowd, he told me, "Young man, you should go go for your honeymoon to New York and Paris and London. You should arbitrate in Bangalore." And that conversation ended there, but I followed it up during lunch, and what came out of it was that there are a lot of things that these institutes are doing that we're not aware of per se. So as things stand, there are about more than 35 institutes in India as we speak. A lot of them PSU institutes. A lot of them are specialized institutes that are available in localized centers. However, the thing is that, number one is that people, the practitioners, the academicians, or the people in the industry don't know about their existence. They don't have a website. Even if they do have a website, they're not active, or they don't publish data accordingly. Even if they do publish data, they're inaccurate. And more so that the lack of transparency is directly connected with the trust associated with these institutes. So, like everybody discussed on all the broad topics today, I think there is not much further scope to venture in this. We have to make sure that the authenticity and the awareness is there, of course, because when we deal with clients in middle quantum disputes or lesser than high quantum disputes, the nature of the client is that to save money now, okay, and they don't realize that by saving money now, they will be spending a lot more money later. Now that is extremely difficult for, as a practitioner, to explain that to the client. That is not, it is my responsibility to a certain extent, but not in totality. There is a huge gap in understanding what the institutions are doing. Of course, MCI is doing a great job. We can see that in what they are doing. The Supreme Court, I think this year, late last year, has referred, 2 mandates in their own judgment without any reference to the MCI, and they've appointed arbitrators as well. Now, as things stand, we do see an institute leading in a direction where we should be going, and the benchmarks they've taken from institutes which are abroad. As we've already spoken in this discussion, that India is known to be the largest exporter of disputes, as the numbers say. I think we are second in the SIIC dispute module, and I think the ICC we are also second or first, I'm not too sure. However, in relation to how many arbitrators from Indian origin are appointed, are fairly lesser. I think out of 300 arbitrators that are appointed by SIAC, only 18 are of Indian origin or Indians per se. So there definitely seems to be a disconnect between what the standards are and what the standards should be as things stand. So I would connect and would like to keep it short and connect what my observations are essentially to 2 points. That is to make the system uniform, make the system institution should be much more transparent, in letting the industry know of what they are doing. I do not see any problem in publicizing themselves. I think that is in contrary to what Mr. Satvik said. However, that said, this is my personal opinion. Having said that, that only gives us the idea of what they are doing, whether we can rely on them, whether we can whether we can consider them to be a watchdog and keep us within the lines of arbitration. And one important problem that I have faced during my tenure of practice is in the ad hoc system. The whole system of arbitration, like Mr. Karia pointed out, the arbitration begins with the judges asking about their fees. On a morning when you're prepared to, let's say, you've read your case laws, you're ready to cross, or you're in your zone, and then you have to deal with, let's say, fees requirements of arbitrator. That should be the last thing in your mind to take care of at that point of time, and ask your clients, why haven't you paid the fees, and where is the fees? Have you deducted TDS? It's absolutely haywire. Okay, and so that and I've seen the coffee is also better in the institutional arbitration setup, so that's always a win. So those are my couple of cents. I do not want to repeat what everybody has already already said. So yeah, thank you.
That's the one way to attract the client. If you provide them good coffee, drinks, just give them a choice in the room, and they feel that this center is very good. This is a very simple way to attract, and maybe the good way to advertise. So Anubhav, very nice. Thank you very much for sharing that. And
Dr. Rajesh, I just want to mention that Anubhav, I wasn't criticizing the promotional events of the activities of the center. I rather commended that and said that they are the sole driving force behind the promotional activities. We need the businesses and the governments to join hands with them. So I was rather commending them instead of criticizing them.
Okay.
Oh, it's good. We will talk about this one. Advertisement of one's Indian center in India is one issue, but we have to take it at a higher level, that how we can advertise India as a place for dispute resolution internationally. And that is the challenge which we will deep dive later on in that one. We have two speakers have not joined, but I see Simon is here. Simon, I think you are wide awake now. Have you taken your coffee? And if you
Unfortunately, I don't drink coffee, so I'm not attracted to institutions only by virtue of their coffee, but they might offer some tea to me, so that will do as well.
Or wine and cheese will also do, maybe.
I agree.
Anyway, Simon, Simon, one thing is that from Geneva, when you see the arbitration and the arbitration practice and whatever you hear about India, and your experience and interaction with Indian arbitration lawyers or client or anyone, what is your experience and what you have faced and what you would like to see in future?
That's two very broad questions, which I'm very thankful for, because I'll follow Satvik as well and go completely off script. I feel very sorry for my research assistant on that now, but let's go completely off script. So my experience with India in general is twofold. Obviously, I have lots of Indian friends, starting from my uni days, where I met them. Also because with Anubhav, we've done a series on investment arbitration in India, so we're regularly in touch. But then in our global strategic litigations and arbitrations, India has come up more frequently in the past years. Obviously, because there's lots of Indian businesses that go abroad, and well, in order to have business relationships with foreign parties, or foreign parties, not only Swiss parties, but also of course lots of English parties, Americans, other Asian, Chinese parties. They want to have business in India, and then obviously, well, it's got the foreign investors that are coming as well. So India has actually started to gain a lot more prominent place in the international arbitration and litigation sphere, which I highly like, which I really like actually, which is something that is really useful, because as I don't remember who brought it up, but the younger generation of students that I'm seeing as well, there's so many young people that are interested in arbitration that go and read law and read arbitration courses in English universities. They come to Geneva, to the MIDS, they go to Stockholm, they go to the US. So there's a massive pool of young people pushing back up, which actually brings me to one of the points which I can connect with my experience with Indian arbitrations. And that's something that one of you has already mentioned earlier. India, I think the Indian arbitration society has to move away from the thought that only former Supreme Court judges and former High Court judges are good arbitrators. And that's a fact. If you look around the world, I feel like giving the opportunity to younger arbitrators, and by young I refer to all of you, of course, is something that is really useful. Not only from a technology perspective. I'm not sure if I like virtual hearings and if I like to talk to you right now. I feel really sorry that I can't be in India right now. It's a pity that I haven't been able to travel in the past 2 years. But also just from a different mindset perspective, I think 𝗬𝗂, he mentioned it earlier as well. It's a fresh mindset that needs to be brought to the entire society, the arbitration society, let me call it like that. So in a way, and I agree with one of the earlier speakers, it's not that really a setback, but it's a challenge that needs to be faced, and that's a challenge that can be met and easily be overcome. And that is something, and I refer back to Satwik's comments earlier, and actually 𝗂𝗵𝗲's as well, the entire institutionalization of arbitration in the Indian context is something which has to be thought through very diligently, because what was good in Hong Kong, which was good in other countries, I mean, you all of you have probably heard of Dubai's latest move, and the government intervention is good to a certain extent. So sorry, Satwik, for going not against you, but for limiting maybe your thoughts on that. But government intervention is very good to a certain point. So if you want to institutionalize arbitration, you always have to ask yourself, do you want to have an all-Indian arbitration institution that has local offices and that is kind of responsible, that can be like the big Indian arbitration institution? Or do you want an Indian arbitration institution association? So do you want local offices, local branches, the different institutions all over India that are part of the same umbrella, an association? Or do you want to have it completely decentralized? I mean, centralization is always an interesting topic. If you look at France or the UK, both countries are insanely centralized. If you look at Switzerland or Germany, both countries are really decentralized. I think India, and maybe correct me on that, I mean, of course, Delhi is a big hub, but knowing the Bangalore arbitration community, knowing Bombay, I think there's big hubs around India as well. And sorry for all the other hubs that I'm forgetting now. But that is 3 different models, and there's probably many more models that one can think of. So I don't know where the government could hop in on that, but it must be a joint operation of the institutions, of the practitioners, of the businesses, and of the government. And now that I've gone completely off script, I've shared my experience with you, my thoughts on that. And I'll play the ball back to you, Raja. Thank you very much.
Thank you very much, Simon. You really preempted my question, which I was going to put the whole panel now after the first round. But one thing is that good that from Geneva and your interaction with India, the one positive thing comes out that even you as an young, I can make you happy on Sunday again, even young lawyer and arbitrator are interested in India, and you see the potential. And this everybody is saying. And this is the common theme has come out in the opening remark, that everybody is upbeat about Indian situation, and they all have a positive feeling about that the Indian situation or arbitration scene is improving, and the centers will do good, and institutional arbitration is good. We understand that. Having said that, this is my question open to all of you, that if we have to design or think about how India should run the institutional arbitration, should it be one centralized system with the several branches, or should we have one flagship institution and let the state decide, let a state also have its own center? It should be a spoken wheel kind of a situation or a series situation, what it should be. What is the thoughts of government? What is the thought of practitioners and institution we would like to see? And in this one, I particularly like, first I will invite Mr. 𝗬𝗂𝗏 because you have been involved in the government committees. So you must be knowing inside a story of that. And then Mr. Rajdeep, you also know, you have been in practice and you are involved in the new center. So you should be knowing. And then I will ask our institutional experts, forget about like particularly Shweta and Smriti to think, forget about that you are representing SISE here or AAA and Iram as an Indian. Tell us that what should be the best model for India to pursue? Do we have a consensus on that, or do we have any imagination on that? So first, Mr. Karia, and then Mr. Chaudhary,
Sure.
and then I will invite other panel members.
Yeah, that's a very interesting thought, and we have been grappling with that issue of not having a prominent arbitral institution for India. Now you see, Singapore has CAC, London has LCIA, we have ICC in Paris, and we are competing with, India is competing with all these cities or city-states, whereas India can never be a hub. We need to literally talk about India is not a seat. You cannot have the seat of arbitration as India. You need to identify particular cities in India to have a hub of arbitration. And to do that, we will need to have a robust arbitration centers there. And we cannot have a drastic difference in the manner in which these rules will work or the administration will work. We need to have a very prominent arbitral institution. I'm not suggesting we should have only one. We can have more than one, but there has to be consistency amongst these arbitration centers, and they should be having a collaborative approach. And there is no competition, because what we all are trying to achieve is India being at the forefront of the arbitration regime, and we doing the arbitration the way it should be done. Not Indianized arbitration, but the arbitration the way it is done internationally. We have to do it. And to achieve that, we need to identify particular cities. We need to bring the Anubhav, if you can put it on mute. Sorry. So we need to put India in a map where we will have prominent arbitral institutions in few cities. They have the rules the rules should be consistent, and they should be able to use the strength of each other. In the sense that if you have an arbitration in Hyderabad, then MCIA does not have to set up the entire establishment in Hyderabad, and Hyderabad Arbitration Center can provide the infrastructure. So that kind of structure would be very helpful. We need to see that if there are any gaps in the rules, rules can be amended to bring at par with other institutions. Mostly all the rules are very similar because we are following international standards. But that is something we should think about it. I'm sure there may be different views on this panel. Some people may not agree with me, but these are my thoughts, and I'm open for ideas from others as well.
Thank you very much. This is what we want to have, the short reply from everyone to think about which model will work. So, so Mr. Chaudhary, you tell us. I know your arbitration center in Hyderabad is doing well. So perhaps you will agree with Mr. Karia, or you can have a different, just tell us for the betterment of India, what do you want to see?
Yes, I broadly agree. Look, India is just too unique to follow anyone else's footsteps. India cannot be compared to China because China is a command economy. The government, the executive works in a different way. India cannot ever work in that way. India cannot be compared to any place in Europe or in say the US or this island off the coast of Europe called UK. And the reason is that we are just too diverse. We are geographically diverse, we are culturally diverse, we are linguistically diverse. There is a digital divide that prevails in the country. There are other physical hurdles to making everything a level playing field. I think what we should do is encourage many institutions, let the market forces decide which institution will survive and which will thrive and which will collapse on the back of its own inherent inefficiencies and weaknesses. To compare is dangerous, but I think we should also just compare in order to get some perspective. China has, for example, I understand China has some 270 institutions. Of course, not all of them are world class. Not all of them have a huge sort of caseload, but places like the CTAC is leading in terms of the volume. China has other, you might say, peculiarities, but you can also call it uniqueness. I'm told that the concept of ad hoc arbitration is not recognized in law in China. I understand that institutions, when they have very deep pool of arbitrators, it is not possible for parties to nominate people from outside that panel. So that itself will give rise to the institutions perhaps being able to drive a policy of diversity in the pool of arbitrators. That's one benefit of it. But coming back to India, I think we need many institutions. There are many centers. I understand that recently the MCIA launched an initiative, I think with WeWork or with one of these workspace service providers. I think one of the issues of geographical distance can be overcome if we embrace digital solutions, if we embrace hybridization of virtual technology in the conduct of proceedings. Of course, that requires all kinds of other hardware and software issues, but that's another challenge that we can take up. So that's my short answer to your question, Dr. Sharma.
Thank you very much. May I invite Smriti and then Shweta? Don't think about AAA and SIA. Think about India and suggest that what should be the good model.
Thanks, Dr. Sharma. I think I would like to resonate on what a lot of people have just spoken about. The focus shouldn't be so much as to should there be one institution or multiple institutions, because India is a really large country, and what works, for example, in one part of India does not work for the other part. Similarly, what works for one sector what works for aviation in arbitration will not work for construction arbitrations, so on and so forth. So the focus should be on creating a space, and I go back to the word that I used before, a cohesive space where businesses are able to communicate with the lawyers are able to communicate with institutions. There's a lot of best practices doing the rounds, and each institution really, at the end of the day, almost all of us are working off UNCITRAL rules. All of us are working on a sort of homogenized platform with innovations that are doing the rounds. So the focus should be on creating that system, building arbitrators, having the judiciary interact more, so having commercial parties interact more with arbitration, giving them capacity building, creating not just arbitrators from India, but also creating awareness among parties as to the benefits. I think the focus should also be on modifying rules, modifying procedures, with an eye on what works in India. For example, if cost is of the primary concern, or if confidentiality is primary concern, and I will like to draw an example on something that happened to us. The parties were very open to a virtual hearing, but they had no access to computers or with a secure background. So what worked for us was having an MOU with another organization in India. They just opened up their very secure computer portals for people to access. And in that way, we were able to overcome a lot of the challenges, like technological challenges. So I think the focus is, and I know we all sound like broken tape recorders, but that is the truth. The focus should be on collaboration, on cohesive participation. And I have been a strong proponent that India needs to develop an ecosystem. And by this, I mean, and this is, I go back to the example that someone raised of China and Singapore and other jurisdictions. The way to start, like Mahatma Gandhi said, is from bottom up. So we need to look at ensuring that when people think of disputes, arbitration is not an afterthought. Arbitration and mediation should, alternate dispute resolution should be an automatic. And then from there, we can focus on other silos which become important.
Thank you. Thank you. ଶ୍ୱeta, your take?
So just quickly, from what I recall, in 2016, NITI Aayog organized something and brought together different institutions, where the Prime Minister also sort of highlighted the need to build a dynamic system. And I think that really was the answer. Now the point is how we're able to execute and put into action what really was set in motion with that declaration by the Prime Minister himself. And to build that dynamic ecosystem at different layers. Of course, everyone talks about that India is a very different jurisdiction. And it's not fair to even compare India with Singapore or Hong Kong. While we can learn from their stories, there is a different story that India will have to write for itself. But to get the broader picture in perspective, I think we need a strong judiciary, and everyone has recognized and we see the results of sort of unfolding. We need a strong infrastructure, and that is something we can't overlook. And these are some of the learnings from Singapore that I think that India can replicate. When you're looking to establish a seat, bringing foreign practitioners up, and it's not just for India-related, where the Indians are parties to the contracts, but also you have two foreign parties seated in India, and that's really when you look at that India has arrived and is looked at as a seat for arbitration. So you will need a strong infrastructure in place. You will need laws that promote and support arbitration, and also recognize in a way to a certain extent even institutional arbitration. So it has to be mindful when it's developing its laws that it's not only for arbitration in general. And I think the initiative that Maharashtra took about for mandating for arbitration matters which are of a certain values, I think that is a good step that was taken. We didn't see many other states roll out similar policies. Those are policy decisions that the government could take. To a certain extent, that's a good borrowing from China, where they have made it literally, to a certain extent, institutional arbitration. We will need flagship institutions, maybe not one, multiple. I think we heard of the IAC coming in, but institutions which stand as a model of good working. It's not about the number of institutions. It's not about having 200. But if we are able to establish strong institutions of absolute gold-class standard of administration and arbitration, I think that's where things would really begin to change in terms of how we're doing. And not just hearing facilities, I think just the working of the institution itself. And lastly, it's the arbitration bar. That's what needs to. India needs to become really a thought leader in this, taking that step forward. And I think today's conference is a good step, because when we really work together to understand at policy level, at these different levels, what is it that we can do to change things? Arbitration bar to really stand as a flag bearer, to sort of make things move in India much faster. I think when our response time needs to be faster. We can't be sitting. The world is moving very, very fast. We're changing rules, things are evolving all across the world. With the way even institutions are functioning, I think we as India, as a country, and coming together. Like I never think that it's really a competition between SIAC or the Indian institution. I think globally we are on the same platform. There are so many disputes. If you look at the broader picture, if we get caught up in these minuscule issues of competitiveness, we will never be able to grow. We will never be able to sort of solve the bigger problems. So we need to be able to come together and look at the broader picture, and that's when you will know India will just grow leaps and bounds and will not be caught up into these minor issues of regional competitiveness between institutions or even with international institutions. It has to be at par. That's where I have a vision. This is what India should be in the next 10 years.
Thank you very much for giving a very, very objective assessment that how it should move forward. Iriam, what is your short answer to that? Which kind of model? But don't
Short
think
answer.
about.
So mandate has been, put on me the short answer. So I'll be very quick with 4 or 5 things. See, one thing, because what my co-panelist has just said and mentioned, so I would like to comment upon in brief that few participants, few panelists has said that why we are, exporting all disputes to CAC and so, why we don't have any, because for London LCIA, for Singapore SIAC, but we do have 𝗵𝗃 for India now, and you will not believe that how difficult it was to get registered in India. See, Dr. Sharma was instrumental in setting up this, 𝗵𝗃. He is the head for the accreditation committee, and he's silent on that. But the thing is, see, you will not believe that after surveying everything that we have, every centers for every country, why we are not having, institutional, international institutional setup in India. So for that reason only, we ran pillar to post, to get it registered India, because Asia Pacific was not easily registered in India. And when I have to, give so many applications to the Ministry of Corporate Affairs, that because we wanted it to be registered in India. And Australian people, they got the name. Hong Kong people, they also got the name. But we were like, like fighting. No, we want this to be in India, because every country has international institution, but India is lacking. Just because of that, and patriotic, feeling came up, and we got it registered in India. Luckily, after pursuance of, so many applications to PMO office and all, we got it registered. So we have a very big canvas. Everyone has their own pie. How to color this canvas, what painting you want to put it on there, that is up to you and up to us. This is the first answer. Second thing I would like to say, that institutional work will be during the tribunal, when the arbitral tribunal will work. But there are a lot pre and post. So pre and post has to strengthen. See, somebody says, why CAC and why Singapore? Why not India? I'll give you one example. Suppose one case, similar facts will be decided in Singapore, and a similar case is being decided and award is published in India. And within 3 months, let's say 6 months, fast track. But if one party who is aggrieved in Singapore and another party who is aggrieved in India, they want to challenge how much time they will get to get the finality of the award. See, let's say 2-3 months, and in India, how many months? Years. So that is what we are lacking. See, it's not about only the duration of the arbitral, disputes has been decided, or the adjudication of the arbitration only, but pre and post. This we have to strengthen, and that is why I said in the beginning that we have to work as a unit. If the arbitration time is being given 1 year, then the deciding a 34 challenge has to be given not more than 3 months. So that is what we have to work, and that will create a lot of confidence, and change will happen, because people are not having confidence. So that is what one thing I would like to say. Another thing is like what others says, that how we can create more awareness, bringing international lawyers or the foreign lawyers here. See, we are bringing international institution. Why we are banning international lawyers? They are more adapt into institutional aspect or institutional framework. So by bringing them here, we can also learn new techniques and all those things. Now after the schedule has been amended and act has been amended, so now we have that ordinance passed in 2021 amendment. By this we can do it, but why we were scared of that? See, we are talking about institutional. See, arbitration or institutional practice is not only for the domestic purposes. It's a global profession. So let everyone will decide its fate. It's not about my country. It's not about your country. It's not about CAC. It's not about HKIAC. It's about arbitration. It's about institutional practices, and we have to work together. And they will not be far when we will be having an ADR clause, which will say that I will be using the panel of so-and-so, I'll be using the online platform of so-and-so, and I'll be using the case manager so-and-so institution. So we should work towards that. We have to be that optimistic. That's what I said. If we have a very, very wide canvas, we have a very big canvas. It's up to us how we use it. See, arbitration is not like per se his or her or something, but we try to cage it. That is the issue. That is the issue. See how many females you see here in the arbitration. That is the problem. We have to bring more females. And see, I keep on saying this everywhere, because handful of females are there into arbitration, because the parties don't trust into females, that they said how they will be able to understand the commercial contracts. And also, see, we can do best, and we are doing it. So that is how a lot of changes can be there. And what Smriti has mentioned about the collaboration, see, that is what we have come up with the 𝗓𝗏𝗄𝐺ate app. The 𝗓𝗏𝗄𝐺ate app is a complete online dispute resolution platform where you can select your arbitrator, where you can resolve your dispute in any way, either arbitration, mediation, or negotiation. So that is the customized platform. What we are doing in India is a virtual, it's not online. So we have to have a dedicated platform for completing this. So technologies, in terms of technologies, blockchain, ledgers, all those things, see, we have to understand a lot of things. We have come, only I must say halfway. We have to go very far. And mediation and arbitration or entire ADR, if you see, it's not adversarial. It's not my way or your way. It's way forward and way together. So we have to work together. We have to work together, and then only we can change and create the change. So it's not about you and me. It's only for me, arbitration or the ADR or the mediation. For me, it's only subject. It's not only object. So that's what my take from here. And thank you so much for this discussion. And today I realized that this discussion can create a roadmap that how the institution should work together, how the judiciary should work together, and how the colleges, because the platform which has been given to us is the college. So see who has given this platform? The college. So everyone has to work together, and it is a way forward. Thank you.
Thank you very much for your passion. Yes, we are all working together on this one. Before I move forward, may I ask a panel member whether you would like to take a short 10 minutes break, because we have been going very long. So maybe to grab a cup of coffee or bathroom break. So should we take a 10 minutes break? Okay, good. So 𝗓𝗏, what time we should be back? By my time is 6:20.
So ideally by 1:15. I'll just move all the panelists to the panelist session also. You can either unmute or talk there, or you can just turn off your video, turn off your audio, and take a break. So till then we can reconvene, and I'll move the panelists at 1:15 around.
Okay.
10 minutes.
10 minutes. Good.
Yes.
Thank you.
Satvik sir, did you receive the invite for the panelist breakout session? I think you're on mute, sir. Sorry.
I'm sorry, am I audible? Yeah.
Yes.
So, I see a prompt where it says that breakout sessions have started. Like, is this the one you're talking about?
Yes, sir. Yes, sir.
We were leaving the breakout session and coming back to the.
No. We were in the main session actually. Yeah, it's the other way.
Right. Now we are into the breakout. Okay, right. More like a panelists lobby.
No. So you're not in the panelist lobby, right? You're still in the main session.
I will be.
Yeah, you will be. Correct. Yeah.
Sure. Just
No problem. I welcome back all the panelists for continuing with the discussion. And I now pass on again to Dr. Rajesh to lead this panel in a brilliant discussion.
Thank you very much, panelists and the audience, for enjoying your 10 minutes break. And after break, we are back again here. And since our one panelist, Simon, has to go very soon, so I will ask him to tell. He already said that which kind of a model he wants to see in India. But before he leaves, can he also say one thing, is that whether you want a center in every state, every corner of India, or you want centers specializing in certain field, that's how we should diversify. And what kind of rules you would like to see as an institutional rule for arbitration? Your comments on
Thank
that.
you very much for the question. I love this kind of bottom-up approach, as we called it earlier, and which is actually very closely connected to some sort of constitutional law, right? You create something, create a statute, you create institutional rules, so you create systems, institutions, whatever. Difficult question. I agree. Well, I actually think that regionalism is something which is to be promoted. So if there's two parties from Chennai, why would they go? Well, why would they go to the other part of the country to arbitrate there? So regional, at least offices or representational venues would be really, really helpful all around, spread across the country. But then again, if you have a party from Bangalore and another party from Delhi, that kind of neither of the parties would maybe feel comfortable to just go and see the other party where they are living. It's kind of like the Apple and Samsung case, right? Why go to the US to litigate? So maybe a third neutral forum would then be advisable as well. So long story short, I think regional offices of an institution are really helpful. I highly doubt that regional centers, like regional institutions that then work under the big umbrella, are the best way forward either, because everything would be split up, right? What you could do is have this big institution which has regional offices and then split in different chambers, specialized chambers. You've got the construction arbitration panels, you've got the aviation panels, whatever, where you have specialized arbitrators and maybe also clerks, by the way. I think Tejas mentioned it earlier. He said sometimes it's good to receive a reminder notification from the institution that you have to reply to something, that you read something. Well, if you've got a clerk who's done lots of aviation arbitration, they might pinpoint something in the dispute that the arbitrator should think about as well. So yes, I think having hearing centers all across the country is useful, and having specialized people and maybe chambers within the bigger structure would be a good way to start. But there's so many other options as well. So I don't want to say that this is something that must be done. I think there are various models that must be well thought through before actually starting to put money and more time into creating something like that. And by the way, thank you very much for having me. I know, sorry, I have to drop off. I can already see some emails flowing in where I am right now. So thank you, everyone. It was great pleasure meeting everyone. And I hope to speak to you soon.
Thank you so much
Thank
for
you very
joining,
much
sir.
for your time and waking up early morning to come here.
We're certainly
Thank you.
very grateful and inspired. Thank you so much, Mr. Vaibhav, for joining.
Thank you, Kush.
Have a nice day. And that brings me to Anubhav. As a counsel, as a user, what would you prefer? Do you also want the arbitration center everywhere in India, or you want the center a specific of kind of a specialty you want?
I think being a practitioner in India, I mean, I might have a slightly different approach to this. Whenever I'm asked a question of this sort, I'm reminded of my constitutional law professor, who before teaching us constitutional law used to often come up with a quote by a Hindi poet, which often went like this: that India is such a diverse country that meal pe badle bhasha, krosh pe badle pani. So what it translates to is that in every mile, the taste of the water changes, and when you go a little further, the language changes, and that is the diversity of the country that we stay. However, having said that, my opinion on this is very, very streamlined. What I would prefer is that it becomes the quality or the reliability of an institution, in my opinion. If we have multifarious institutions, each of these, to maintain the standards, it becomes difficult. So I would like to agree with what Simon said and left before this, is that what is ideal is that having offices of these institutions in regional setups, okay, and maybe the panel of arbitrators that they encapsulate and captures various specific areas. Please pardon the background noise. My neighbors' dogs have been a bit haywire. But having said that, I mean, having regional offices is definitely much welcome. Now, I would also want to state one more thing, that in Bangalore, in a few arbitrations, I mean, the technology aspect that we've seen, has been advancing in a great manner. So even in a few ad hoc arbitrations, we've been able to, instrumentalize and get the parties involved in using a certain kind of an application, okay, which have of course gone through several tests and tiers of beta testing and so on and so forth. But the thing is that it's so secure. I mean, and this has been instituted by the Bangalore Arbitration Center. It's basically that what filing is left, when you are due to do that filing, what fees is remaining, what are the next dates, everything you have, all the parties and the parties council have it within an app, and all the necessary documents, and it's password protected, in a twin layer phone number protected. And it's great to see these advancements, and I hope that arbitral institutes are much more amenable to technological changes going forward. I mean, and that would be a great thing to adapt, because I mean, COVID showed us that arbitrations and cross-border arbitrations, international arbitrations, can be conducted uh, through the online media. And for that to happen without any glitch is essentially making sure that the transparency is there and everybody is accessible to the same resource. I mean, the same the portal platform that is available to everyone. So if we can slowly remove these hurdles one by one, I think that's definitely a good step forward. I mean, of course, I thank the organizers for putting such a great event right now, but again, I have also certain reservations against the word setback. I mean, because I don't really consider it to be a setback, because I think for such a huge country, the disputes are multifarious, okay, it takes time to bring uniformity within the country. And I think that we will soon be seeing something, with people like us, deliberating on it, discussing on it, and accepting the best practices that are available in the market, and keeping our minds open. I think that's the most important thing that we have to keep in mind. So these are my 2 cents that I have to share on this.
Well, it's certainly not 2 cents. At least you can say $2 minimum. So it's a good thing to see for how the users, they want to have this kind of an approach or centers. So it's good to see. So Satvik, what's your view on that?
Well,
you are legal advisor to the government.
Well, I just want the government to actually establish an independent, I don't know, panel of arbitrators. I don't want to call it a panel or a pool or a center, but see, the thing is that we need a hybrid system. I agree with what Simon was saying to a certain extent, flowing from what I said in the first session, that we need specialist arbitrators. So Simon came from a school of thought that we need specialist arbitrators sitting in a particular region of the country, right? Maybe that may not be as practically wise. Maybe someone's into aviation dispute from the part of the country where all the aviation dispute arbitrators are sitting in another part. Again, it just defeats the entire purpose of having that arrangement. So I'm actually in the dark, because there are pros and cons of both the models. But I think what we need is that, despite the fact that we have different centers of institutional arbitration in India, we need to have an overarching guidelines / probably a regulator or a body of sorts, an independent body. Because you see, the thing is that in arbitration should not be restricted only to lawyers. My belief is that, because I'm also a lawyer, but then my belief is that we need that expertise from the I don't know, sector expertise, so to say, because that's where you would, as a client, if I'm a petroleum agency, I need to be sure that my arbitrator understands the industry of petrochemicals. And an arbitrator might know the laws around petrochemicals, but there are high chances that they might not be able to appreciate the technical aspects of maybe the chemistry behind it, so to say, right? So I want the status quo to be retained, where you have different institutional arbitration centers in the country, because let's look at the geographical advantages which Hong Kong, Shanghai, London, Paris, Singapore have had. Obviously, the comparison can't be made because the expanse of the countries and jurisdictions are small compared to India. But if they can operate and benefit from the geographical benefits, so can we. Maybe the government arbitrations, if at all the government starts including institutional arbitration in its contracts, the government arbitrations can revolve around New Delhi for certain sectors. Maybe if it's related to marine industry, maybe obviously it could be Chennai or Bombay, for example. If it's coal industry, maybe somewhere around the Chota Nagpur plateau, we can have maybe Calcutta can come up with a new. So things like that. We can again. I'm harping about government, but is the same for government. Should take the lead on that, because in India we know if the government does something, and if the people understand the value of that, the people would follow suit, right? So if suppose onboarding the electronic vehicles, right, in India, in the name of pollution, I'm sitting in Delhi has banned diesel and petrol vehicles, public vehicles right now. What if the government actually, all the government of India vehicles are EVs now? Then as a private vehicle owner, I would be like, okay, the government can do that at a large scale, I can do it at my level, right? So that's why I'm harping about the government, saying that maybe these centers of arbitration can be streamlined and homogenized amongst themselves first, with respect to Indian arbitration to begin with, as a phase 1 step, and then maybe we can move on to see where we can include international arbitration disputes in the form of institutional arbitration dispute settlement mechanism. So maybe that's a little confused, a little complicated, but my couple of points on this question. I think a hybrid model is the best way to go about it, maintaining the status quo.
Thank you very much for your view. It's not unheard of. When Perth started the mining and mineral arbitration center, their justification was that the whole mining area is in Perth, so why they should go to Sydney? So it is not unheard of. This model is there. So we have to think about in India, but it's also one view that you saw that whatever the dispute we have, we should go there. Maritime centers should be near marine area, not in the central area. So it's normal. Good idea. Like, we can explore all models. Why not? So good there. Before we move to another theme of today's discussion, I just at this moment I want to acknowledge 𝗂𝗵𝗲 𝗖𝗶𝗂𝗺 for his contribution today. As lawyers have to chase the money and the client, so the client is chasing him, he is chasing money, and he has to go after the cases. So he's leaving now, but panel is still here. So thank you, 𝗂𝗵𝗲, for your contribution today. It was a pleasure to have you here. Now, I want the panel members to think about the second question or the second theme which we have, the rules for the arbitration. Which kind of rules we want? We want an international arbitration. Oh, Mr. Chaudhary, you raised your hand. Sorry, I missed it.
No, that's all right, Dr. Sharma. I just wanted to come back on a point that Mr. Sinha was making. I think before he left, of course, he was talking about the I think initially he started talking about a virtual hearing and how we need to do things to make it more practical. I just wanted to say that, look, at the end of the day, every arbitration is a trial, and we all know that the cornerstone of trial is evidence. And as of now, the Zooms of the world, all these typical video conferencing platforms, were never designed or coded to help people conduct trials. You know, they were coded in order to have much more straightforward, less demanding group meetings at most. I think the immersive experience that we need as lawyers in terms of how we ask the arbitrators to absorb and understand and evaluate the evidence, I think that's obviously a weak point in the Zoom platforms and similar softwares. But I think we've all understood in the last 9, 10 months or 12 months that virtual hearings or hybrid hearings are here to stay. I think there's enough data and studies to show that it works. It has a few, it's a bit rough around the edges, but we need to find a solution of how to present evidence electronically in a way that we can get the arbitrators to immerse themselves in that evidence. Now, I know that there are efforts going on in the technological sector to come up with bespoke softwares for conducting adversarial proceedings. And once those take off, I think it will be a huge boost in the arm for virtual hearings, because virtual hearings otherwise are win-win-win for clients, for lawyers, for arbitrators. The only issue is how do we deal with certain aspects like presentation and consumption of evidence. And I look forward to finding digital solutions maybe as early as next year. And that will give a big boost to virtual hearings, which can only be a good thing for us practitioners, arbitrators, as well as clients who end up paying for the experience. That's all I had to say. Thank you.
No, thank you very much. I mean, that can be part of the arbitration rules or institutional rules, how to conduct arbitration online. And that's why KCAB, like Korea, South Africa, and Hong Kong and Singapore, they all come up with the protocol or the online arbitration protocol. So it's good to see the development, the new things which has happened. So coming to the point that I want all of you to think about that, which kind of institutional rules we need in India. Because without, yes, Kusagri, you have hands up?
No, sir, please continue, please continue.
Yeah, so which institutional rules we want in India, because any success of any arbitration center is also their rules. So we need to think about that, which kind of a rule we want. Do we want UNCITRAL rule, just to take it from there because it's decided by UNCITRAL, accepted by wider community, known to all? So should we take that? Or should we take the best practices from everywhere, pick and choose? And if we are doing it, we have to also think about that. Every center come out with something like AAA, come up with the emergency arbitration. Singapore come up with the early determination system, which was based on ICSID model and all. But what I'm thinking about, that as an Indian like arbitrator, if you are designing the rules, would you come out with something new, innovative rules, which you can claim that is an Indian contribution to international arbitration? Should we have something of that type, even if it's Indian based? I see, Shweta, you have a hands up on this one.
Yeah, just quickly my thoughts on this. Firstly, are you able to hear me well?
Yes, ma'am.
Yeah, okay. So, while we are debating and discussing on which rules would be the best, I think firstly to understand that each rule, the UNCITRAL versus the other institutional rules. UNCITRAL typically works best in an ad hoc scenario, and that's what they cater best for. So for an ad hoc arbitration where there's no involvement of an institution, and UNCITRAL rules would work well. From the institutional rules point of view, I think we have to understand who the user is. And given that the most important concern for India is really time and cost efficiency, the rules must be able to cater to that. And of course, Tejas in the earlier session had very beautifully summed up the mechanisms that are available. And most institutional rules are very similar in those aspects, barring certain nuances in terms of how the appointments are done, in cases of a joinder or consolidation. mostly the mechanism it needs to provide for, such as the emergency arbitrator, it needs to have expedited procedure, to be able to address multiple contracts related arbitrations, to have joinder consolidation, early dismissal procedure as well. And I think now to be able to respond to the technological intervention in the arbitration, also, whatever the issues that may arise from the virtual hearings, to be able to address those as well. We've seen in the recent past, in fact, from SIC standpoint, we are also undertaking the revisions of our 2016 rules to respond to the new needs. So there can't be a static rule. You will have to constantly relook to the needs of the users, relook at what the changes are, with the moving times, and be able to revise them accordingly. So while UNCITRAL is good for ad hoc, I think for institutional, you will have to find where all of these mechanisms are carved into the rules itself. So maybe for India, if you want to stand to borrow a model, it'll have to be the international best practices. We would have the benefit of looking at, of course, the SIC rules, the LCI, ICC, and also the approach the institution wants to take, whether it's just a soft touch approach or it wants to also provide for scrutiny of the awards. So there are different parameters. While it's easier to put the proposition of which rules, I think it will take a lot of consideration, before we come to a conclusion that these are the ideal rules for the Indian market.
Thank you very much. I see Satwik, you have raised your hand, and Mr. Chaudhary. My co-moderator 𝗬𝗓𝗓 has a question. So 𝗬𝗓𝗓, you can ask your question.
So with all due respect to the panelists who've also raised their hands, I also had this one question directed towards Mr. Karya, and I think this would also guide this discussion in a way, because I believe Mr. Karya was also a member of the drafting committee of the AFSA rules, AFSA, which is the Arbitration Foundation of South Africa. And the question therefore is, how different did you think the rules were for the South African needs? And how do you think that difference arises when it comes to the Indian context? And I believe that interplay could help the panelists also engage in discussions which would highlight the distinct needs of distinct rules in another, if I may, at the cost of repetition, say a distinct environment. So if I may bar the raised hands and skip over just for this particular discussion, if possible, and if the moderator may allow.
Sure, may I? Yes. Okay, so it's a very interesting point you brought, and I'm very happy that we are discussing it in a very collaborative manner, because if you see the arbitration, the virtue of arbitration is flexibility. And what we achieved in South Africa also, or while working with other institutions in India and across globe, is to achieve an international standard. An international standard is uniform. You don't make deviations for country specific thing, because ultimately, if you want to promote international arbitration, you will invariably having parties from different jurisdictions. They may be coming from different cultures. It may be common law jurisdiction or a civil law jurisdiction. So the rules have to be very simple. They have to cater to the needs of all the basic requirement of due process and natural justice. And you have to ensure that all the procedural aspect of arbitrations are covered on those rules. So to answer your question straight, we didn't make any specific changes to one particular country. It was, we in fact compared all the other arbitral institutions. UNCITRAL rules took care of that and made the rules so that it is time tested and it is user friendly. That is what is required to achieve an international standard in adopting rules, because no size can fit all. You have to make tailor-made, and that's why the virtue of soft law is IBA guidelines, you have CIR guidelines, you have so many other guidelines which can be adopted. And we have seen number of procedural orders where the arbitral tribunal has done a picking and choosing of some of the rules, and parties say, okay, I agree to this many rules of IBA guidelines, but I want to create reservation for this. And that is again consent of the parties. Tribunal cannot decide. If parties don't agree, then tribunal comes in and says, okay, we will follow this. Because the tribunal also have to be seen as neutral. in terms of adopting the procedure. UNCITRAL model law also says that the tribunal will decide procedure. Indian Act also says so, and all the other legislation says that the arbitral tribunal will be deciding the procedure unless otherwise agreed by the party, because arbitrator is creation of contract, and if the parties have selected a procedure, arbitrator is bound to follow that procedure. But if parties are not agreeing or parties have not selected the procedural rules, then the confusion arises and you waste a lot of time. And I have seen I'm wasting 2 to 3 hearings, not at one go, but over a period of time in the whole life cycle of arbitration only on procedural issues, which can be easily avoided if you select the institutional rules, because everything is given there. Because the institution, while framing the rules, has thought through what are the issues will come up in the live arbitration. And if not, then we keep revising it. So I've been seeing that all the institutions keep revising. So you have versions of rules of all the institutions which are updated from time to time. So what we feel is that we should follow international standards. There are best practices, and if there is something missing, then tribunals can plug the loophole and put those aspects into the procedural order. But ultimately, there is no country-specific rule. There should be all international standard rules. That's my view. Thank you.
And this is a big question, that how we define the international standard. The basic tenets we know, but how to say that which rule is meeting the international standard, that's another thing. I sorry for my apology if I missed that who raised hand in what sequence, but if you permit, may I invite at this moment, because I'm seeing Mr. Chaudhary, you were talking about the new innovation, TPF and all those things you mentioned in your earlier opening remark. Are you suggesting that those new things should be included in the Indian institutional rules if we want to have a comprehensive rules?
Well, I suppose TPF is sort of not wholly part of the institutional framework, but I do wanted to say a couple of things on TPF, which I'll come to in a few seconds. My initial reason for raising the hand was to say that, look, there's no need to reinvent the wheel. We've already got some global institutions, in a handful of them, not too many, but enough, with their own track record and credentials and experience to know what works and what does not work. Now, I know that each jurisdiction may have its own peculiar challenges and demands and some weaknesses and so on. But I think for India, what you need is an institution that's going to be very much ready to handhold. Because I think right now, one of the weaknesses within the Indian framework, of course, there is anecdotal evidence that about 90% of arbitrations in India are ad hoc. And one of the biggest problems with those arbitrations is process, is a lack of flexibility, is a lack of accountability, is time inefficient, which then creates all sorts of other problems. I think end users need to be shown that institutions are there on the ground. It might be a bit of a labor-intensive exercise, but institutions need to present themselves as having the resources in terms of infrastructure, in terms of personnel, to really police arbitrations, to police tribunals, to police arbitrators with a soft touch, in order to prod them and push them to make the whole process more efficient. Of course, as Shweta mentioned earlier, UNCITRAL is really an ad hoc rules. So in an UNCITRAL arbitration, there is no institution that's administering it or doing anything in terms of the arbitral process itself. There is the PCA that comes into the picture, but that's at a much earlier stage. It's not during the subsistence of the arbitral process. So that's my one point. The second point about TPF was, I suppose, not wholly disconnected, but the issue is, how do you make TPF, or rather the bigger subject of legal finance? I think that's a broader way of looking at it. Legal finance can be a real game changer for all kinds of good reasons in India, and that allows people, or rather businesses, to monetize pending claims, to monetize awards which they already have in their back pocket, but they don't want to incur the time and the financial cost of enforcing those awards. So TPF can be looked at for a different reason altogether. But I think in terms of institutionalization of arbitration, we need the tried and tested institutions to set up shop in India. We need domestic institutions like MCIA and PAC. the New Delhi International Arbitration Center, which has taken over ICADR, that I believe is at a nascent stage of being ready to function. We need these institutions to just adopt their already world-class rules and implement them in a way that gives confidence to end users and other stakeholders that the process will be taken care of. As they just mentioned earlier, one of the biggest challenges to awards globally is due process, because right now setting aside laws have become so strict that it's virtually impossible to challenge an award on merit or on any other way except for due process. Now, if the institutions can take care of the due process factors and considerations and lend a very overactive helping hand to tribunals to make sure the process stays on course and to make sure that the process is efficient, I think that will straight away start acquiring, or rather giving end users the confidence of institutional arbitration within India. Back to you, Dr. Sharma.
Thank you very much. I didn't see that. May I invite Iram? Your institution has rules and you have been using for 20 years. What is this rule? Is it based on somewhere, or it is developed in India, or how you have come up with these rules?
Sir, thank you so much for this question. And before I'll come up that directly, I would like to say about the model law. The UNCITRAL model law, it's a complete model for all the countries, and how the other countries have adopted. Some countries have adopted, like India. So in India, we has completely adopted UNCITRAL model law. Few changes with English Arbitration Act, because it's a our act is combination of English Arbitration Act and the model law. And if you see the Hong Kong, they have customized it. They customized it as per the usage and the that practices, trade practices and the custom and the usages, like that. And if you see Australia and other countries, little bit changes, and they have made in the model law that will be user friendly and the business friendly and the community friendly for their own country. So they have customized even the model law based on their country's trade practices and the usages. So now come to the UNCITRAL model law and UNCITRAL rules. So UNCITRAL rules are very good, provide a guidelines, or may say the GPS for the ad hoc arbitration, international commercial arbitrations. But those are being, done by best practitioners, taking up the best practices all over the world. So that is also a kind of, a format or a model. So we can adopt that, and that is what we have done, that we adopted that and we customized it in a manner which India needs, and the community, the business community needs, and the usages and the trade practices requirement of that accordingly. So then the customized manner we have, we are doing it, and again, because the best part with the rules is you can amend again and again. You can you can change it. You can customize in whatever manner you want. If something new is come up, then you can use that also. So like if you see, and there should be uniformity, as Mr. Tejas and others, I think Mr. Chaudhary has said about the uniformity. Yes, there should be uniformity as per the international aspect is concerned. So that is why, but uniformity with innovation, that is something which is very, very important, that what innovativeness you are bringing along with the uniformity, so that it will be little distinct from the UNCITRAL. We are not following completely UNCITRAL, but customized manner or in some innovative manner. So suppose if you are using innovativeness, so that's what I'm saying, the APCAM rules. I will point out that suppose somebody is sitting in Malaysia and somebody is having another party sitting in Indonesia, they can choose APCAM rules, because these are Asian centric rules, and it is being customized as per the need of the Asia trade practices and about the usages of the Asian countries. So now we see all institutions will be having similar, more or less similar practices, similar rules, like for the consolidation and scrutiny, I must say AMA protocol and all. But in this, I would say we have come up with a very new and innovative rule that is called the project mediation. Because we have come up with the project mediation. See, this is something which I must say that we need to upgrade and update time and again. So emergency mediation and APCAM or in IAM also is the rule which will be providing or selecting two parties who are entering into a contract. At that very stage, they can appoint a project mediator, so that whenever there will be any dispute arises, any dispute during the contract, at the time of making the project, or in the end, in between, any time, they will be connected with the hotline hub. And with the access, just with the button, you will be connecting with your mediator regarding that dispute. And this is, I think, it is like adjudicatory board or the dispute resolution board, but dispute resolution board will adjudicate, but the mediator here will mediate. So that is how you have to be innovative in your rules. You need to understand how the things are changing, because it's like an amoeba. See, what we are talking, it's like amoeba, it may take any shape. So you have to be very clear at what time you have to adopt that shape, and you have to, customize your rules according to that shape. So that is what I would like to say. And my only submission to this regard is what IIM is doing, what APCAM is doing. We have, taken into consideration the UNCITRAL rules and customizing it according to the needs of the users, so that it should be user friendly.
Thank you very much. I see that Shweta has some comments. I raise hand, and Satwik, then I come to you for your views on that. So Shweta first, and then Satwik.
So just
Also,
one on a rethink, maybe one aspect of the UNCITRAL rules that can be introduced into the institutional rule is the list procedure for appointment of arbitrators. I think that that's something which may be of interest to the parties and would be very good. So that was one point that I just thought of. And
okay. Thank you very much for your intervention. And Satwik, your view?
Yeah, sure. So since I come from the trade policy and investment law policy background, I wanted to draw a comparison with first of all, the issue with investment arbitration, the issue with ISDS, investor state dispute settlement. The biggest issue is the lack of certainty there. Now, any dispute will be derailed if there's a lack of uncertainty, and if there's a lack of uncertainty, there'll be a lack of trust, and if there's a lack of trust, there'll be a lack of onboarding of that system. So coming to the question of this session, what system should be adopted? My understanding is that I think there would be more shortcomings and more losses than gains if we have each of the centers having their own rules, because one party of the dispute might prefer the rules of one particular center, and the other party, the counterparty, might prefer the rules of the another center. So what can be the solution here? Of course, there has to be experience sharing. Of course, there has to be an international or a regional platform for all the minds to come together, share their experiences, and there are international best practices in the sector, in this particular sector. When the onboarding has to happen, there has to be a way to enforce. See, it has to be voluntary. Obviously, we can't force it, but there has to be a way where we can incentivize onboarding a set of international guidelines or international rules for that. Like, we're talking about UNCITRAL, for example. Now, UNCITRAL rules can be adopted, can be modified, and maybe a center might not adopt UNCITRAL rules if it feels that their own rules are better. But we have to incentivize harmonization. Here, I'll draw attention to product standards and service standards in the trade area. We have something called MRAs, mutual recognition agreements. LLB students go to Switzerland, pursue their masters, come back, right? So Indian LLB degrees are recognized as a legitimate qualification as a first degree of law in Switzerland or in any other country, and that's why they enroll the students in LLM. When students finish their LLM, they come back to India, for example. Then a recruiter or the people in the legal fraternity, they recognize that LLM as a legitimate LLM. So this is a mutual recognition of qualification and requirements. Licenses, for example, if we are registered with the Bar Council of State Bar Council in India, and we have a certificate of practice in the Bar Council from the Bar Council of India, it is recognized as a legitimate license. Same goes for accountancy sector, same goes for insurance sector, same goes for medical sector. Why not have, probably first of all, the first step is to maybe we need single mouthpiece / regulator / a body for institutional arbitration in India. That single body might enter into mutual recognition agreements with other counterparts in other countries, and then keep on expanding the pool of more and more centers adopting a similar set of rules. Obviously, there should be periodic reviews of the rules. There should be experience sharing. The onboarding of technology is disruptive, right? So technologies change every now and then. Different models and modus operandi can change. That could be brought together, and maybe on a consensus basis can be reflected in amendments to the rules. So I want to draw parallel from the services standards and the product standards in the trade fraternity in the trade region, and to make sure that there's no element of uncertainty, and there's no element of the two parties who are entering into a commercial contract, if they can't even agree on what the arbitration clause would say, then we need to incentivize them to come together. And suppose there is a single set of rules for SIAC and Bombay and London, for example, or if we restrict to the region, Hong Kong, Singapore, Korea, and India, for example. It doesn't matter where the disputing parties come from. If they show that irrespective of which center becomes the seat of arbitration, the set of rules are absolute. There is no lack of certainty. There's no opaqueness actually, and we can be sure to say that in a particular type of dispute, how the system and how the procedure will go ahead with. Because if that certainty it comes to the picture, see, I'm trying to look at the mindset of the disputing parties. We're not looking at the system or the arbitrators, the legal fraternity. We're looking at the business fraternity here. We want them to onboard institutional arbitration, and what could attract them. So because we're talking about rules here, I'm restricting my comment on the rules side. Maybe a homogenization or harmonization, for lack of a better word, harmonization of the rules could be incentivized more, maybe at the industry level, and then that could attract the corporate, the India INC to actually onboard institutional arbitration, irrespective of exactly where the seat or which center actually organizes or holds the arbitration proceedings.
Thank you very much. I think Iram was mentioning this point that APCAM rules is seamless in 9 jurisdictions and 10 arbitration centers. Same rule, same everything. So it doesn't change anything. So yes, that kind of a harmonization may be a good thing. It's only 13 minutes left for this session. Like finally, we are coming close to that. I have one question, which is my personal question to all the panels. Have you ever dealt with a client, a lawyer, or an arbitrator which has some kind of physical disability? And if you have handled it, how you have handled them? And if you have not done it, then what is your view? How the institutional rules or the mechanism should integrate physically disabled people into arbitration? Is it that we should start including them when they become arbitrator, when they become a lawyer, or should we start even one step before to include them in the teaching and training and then bring them in the field so that they will have a confidence in that? It is my view, which is coinciding with the ICC. Actually, ICC has already announced that they are constituting a task force on disability inclusion. So disability is a one point I want you to focus on that from your practice experience. And of course, diversity was mentioned earlier. The women are not invited. So, but when we are talking about diversity, let's also include diversity of what kind, what type. It's not a gender base only, but how many types of diversity we can have. So please focus on your discussion on the disability and then diversity together, if you can say. Mr. Karia, can I start with you? Because you are wearing the hat of ICC and the Indian lawyer, Indian arbitrator, advisor to the government. Tell us, what is your view on that?
Yes, yes. So I would not like to use the word disability. Also, ICC has used the word disability inclusion task force. It is differently able people because
Yes.
they are more prominent in the field. I come from a law college, ILS law college, where our new principal, whom we have appointed, is physically able to not see, and then we have never felt the difference in that. So he's teaching constitutional law, an amazing professor, Mr. Jain, and I have seen him personally acting as a head of the institution without any difficulty. Of course, in arbitration, I have not come across such issues, but it is quite possible that we may have client or a counsel or an arbitrator who is differently abled, and we have to include them. I don't see any problem which can come across in any of the proceedings, but the institution should have specific rules. So as of now, we have not having any specific rules to deal with this situation. But it's a time has come where we need to have such kind of special rules which will improve their inclusion in the entire process. And personally speaking, I have seen it personally, many people are able to perform their task even much better because they have the hearing capability more. If one ability is not there, their other abilities are more powerful than others. And I'm sure if the arbitrators are not able to see, they can hear better than others, and they can make good decisions if they are able to do so. So we need to integrate all walks of life from different cultures, different genders, and again, inclusion has to be holistic. It should not be restricted to one particular type of ability or disability or gender. And gender again is a very big subject. We can have another session on that. But yes, these are the issues we are going to face and we are facing. So we should have specific rules. Of course, it's a tacit approval of all these stakeholders, but ultimately we need to really make it formal. That's my view. Over to you, Dr. Shah.
Thank you very much. Actually, I wanted to use the word differently able, but ICC has used the disability. So I was also surprised that why
I wanted to tell Claudia also that, but then it was a very big meeting. We had an ICC meeting on Commission on ADR just last week, but I'll send a message. I'm sure somebody would have done it, but I'll do my bit as well.
Yeah, I also had a discussion 3 rounds with her, and it's interestingly, and to disclose my interest in that one, I was personally interested because I had this year, every year I have some students who have some kind of physical challenge. This year, when we had an online discussion, then I come to know that in my one class, I have 3 different ability person, one blind, one has a hearing problem, and another has a speaking problem, a stuttering. And then you think about that, doing the negotiation, mediation, and arbitration with them, it was, and then I realized, and then we thought that even in the education we are not doing, and this is what I suggested, that if we don't prepare them, we don't teach them, we don't train them, and we do not include them in that one, how they can survive as a lawyer or as an arbitrator. And that is the practical question. If you find an arbitrator or a lawyer like your junior, he's like, he has some kind of a differently able person, would your client be happy to pay him and include him on that one? How you will convince them? Mr. Chaudhary, you can give your view on that, on the disability and diversity inclusion.
Sure. Thank you. That's a very important question, especially in this day and age. I think it goes back to the other issue of diversity, of inclusiveness. I think we as lawyers, arbitrators, end users, all need to raise, I think, our level of awareness, introspection, education on this issue. I think, of course, it's a no-brainer that we should do all that we can to assist people who are differently abled, but who can otherwise add immense value to the advisory process or the process of representing a client and so on. But in a country where facilities for differently abled people is not up to the mark compared to some other parts of the world. I wonder how much we should be using digital tools to try to neutralize some of the issues surrounding physical access to facilities, surrounding other issues which can create problems. Again, I know I keep harping on about virtual hearings and so on, but virtual hearings, if done properly with the right hardware and the software, can actually help to overcome or at least reduce so many of the other practical or logistical issues that are present in today's modern world. In terms of what each of us can do, I think we need to be open-minded about how we evaluate candidates, whether it's a law graduate in seeking a job or it's an arbitrator seeking an appointment. We need to be open-minded about how we treat that ability or that special ability that person has, and to not see it as an obstacle, but just to see it as part and parcel of his characteristics, which will not, if taken care of, will not affect his or her ability to discharge his role as an arbitrator or a lawyer or an expert witness. So I think it's a mindset, and it's an inclination and a willingness to go the extra mile to alleviate some other problems in terms of physical access or other issues.
Thank you very much. To emphasize that we have to be open-minded, and that may be the first start and the good start on that. I particularly like the digital part. We consider we are looking at the digital part also, and in this process, when I was giving lecture recently, I'm giving lecture with the sign language, and then I come to know the sign language doesn't have a universal. Every country has a different sign language, and then the technological part, they told us that you can create a bot which will do the sign language according to the language, and you can change. It's a coding requirement, you can do that. We have not implemented it, but we have done it. I have already done 4 sessions with the sign language. So far as we discussed with the Netflix, we discussed with the Apple, and we discussed with other, that how they are making the technology. And we were told that in our computer and mobile phone, we have accessibility function, which can do all these kind of things, which we didn't know that before. We talked with the Netflix that how they can make the movie as entertaining for them who cannot see, how they do that. And this is the thing which we are looking at it and learning. So it's a big way to learn. But that's my teacher's hat. So please don't worry about this practical part of it. I'm looking. So Shweta, you are running, you are involved in such a big center with a very advanced rules of arbitration. What is your center is doing to include differently able and a diverse group of people?
So, like Tejas said, I mean, at the moment, there are, of course, no specific rules to address such issues. But from the institution standpoint, there is a definite approach to be sensitive of these situations if they were to arise. And also, as and when the time comes, or if we see the need to be able to respond, with the changes that we need to do in the system that we currently have in place. Which really goes to what Mr. Chaudhary said, that open-mindedness to be able to change what we need to change rather than sticking to where we are. And I think the important criteria, even if where we have to appoint arbitrators, is to only look at their ability to decide and not let any other factor, sort of become an inhibitor in terms of when the appointments are to be made. So whether it's a male or a female, whether somebody's from India or Singapore, or whether someone is challenged in a certain way, so our criteria has to be a good decision maker, an ability to decide the subject in hand, and that's really has to be the focus and not anything else. And in a way, wherever required, to enable inclusion of all kind within the system. I think that's SIAC's approach to be able to take everyone together with itself.
Thank you. I mean, definitely nobody will say that it should not be done, but the question is how it should be done. That is the point. And one solution has come that when arbitrator is issuing the procedural order number 1, the first one in the case management, he should ask, is there any witness, any lawyer, anyone who has any kind of differently ability or challenge, physical challenge, so that it should be included. So perhaps it should be a kind of like a guideline that arbitrators should ask this question, if it is possible. So Iram, coming to you, as an institution, what your institution is doing, or what your rules are doing in this regard?
Hybridization of
Sorry, your sound is not
was
coming.
am I audible?
Now it's good. Now it's good.
Okay, so I have to speak little higher pitch. Yeah. So when this second theme was initiated and we started our discussion, I have no idea that it will end up with, on this note. And this is something which is very, very, I must say very promising, and we should all, accept that. So first thing is, which I would like to say, there should be AA, acceptance and acknowledgement. That should be associated with this very with this very topic. And another thing is, I would like to point out here that because I keep on taking interns, so one of my interns, he was very, very promising. He was very, very techno savvy, and he was like very active and punctual. And I was giving him many tasks, and he was able to perform it seamlessly. I would have never knew that he was not been able to see until and unless my another intern would have told me that, madam, the Masoom is not been able to see. I said, but how come? Because we keep on exchange mails. He is on the LinkedIn, he is on the WhatsApp, and he can see my messages in very quick manner and all. He said, you talk to him. Then I called him and find out, and he said, ma'am, I am having all, accessibility, and I am having that kind of, laptop, all those features and all, and I can do it seamlessly. And then I keep on mentoring him, and he dedicated a poem, on the law octopus to me, that, he's a brilliant student, and he's in the final year of 𝗓𝗵𝗲 University. And so your discussion remind me about him. And second thing is, like, if see, it's not about only the arbitrator, not only about the lawyer, but also the parties. This I have seen in the mediation. So in mediation, there were many times it happens that the parties who are coming into it, they were differently abled. So based on that, now this IIM has coming up with the online platform, that the 𝗓𝗓 app. This is what I have told you. So we have taken care of the sign language. So then we keep on surveying about the sign language, how we can use it as a digitally, so that it could, as you have mentioned, because every country has a different sign language. It is not universally. America will be having different sign language. Other country will be having different sign languages. So we have customized, and we are coming up very, very soon with this, integrating the understanding of the sign language. Suppose the person who are coming for the mediation, they are unable to, speak and all. So that is there. Another thing is, I would like to point out that Delhi, DDRS, they have come up with new projects related to disabled and differently abled people. And also what they are doing, they are training mediators, differently abled people, training as a mediator, and they will be sitting there and they will be able to guide the parties. See, but one thing I would like to ask myself, that suppose if I have to appoint an arbitrator, or if I have to appoint a lawyer, will I be happy with that? So the change should have been, started from myself. Will I be happy? Will I be ready to take this initiative forward? So the change should have been, my mindset will change. Then I will be making other people, to accept that. So first change should have been started from myself, from within. This is first thing I would like to say. And another thing is, like, we have started a project also, 𝗓𝗵𝗲 in the name of 𝗓𝗵𝗲, so that, and you will not believe that people from Brunei, people from, South Africa, many countries have joined that, and that has been initiated by a female whose child was autistic. She has initiated this project. So that is how we are moving this. And as we say that we have come halfway, and we have to go along, and we have to go far places also. So our institution, definitely we are not having the rules, but we are having technology to advancement for these kind of, and to cater this kind of problem.
Thank you very much. At least whatever you are doing, it is working, and we should learn from each other in this aspect. If technology can help, and I'm sure it will help. I'm sure it will help. My apology to panel and guests and audience that we are already 4 minutes over of our time. Satvik, I will not leave you. I will give you fair hearing, fair presentation. If you can make your quick remark on this one, and we close then. My apology.
Well, I don't really have anything. Sure, I don't really have anything to add because everything is. I mean, it's more of a social issue actually. We need to, as said, that we need to appreciate the fact that they are arbitrators by virtue of being meritorious. Right? If they are good enough, they deserve the place in the seat. And maybe as a tongue-in-cheek comment, we have a lot of general counsel awards. We have a lot of arbitrator awards. Maybe there can be a category for especially able arbitrators, so that it actually the recognition in the society improves, not just amongst in the system, but amongst the people as well. So I mean that's what's my very short quip on the point.
Thank you very much. I'm sorry this was not part of the discussion, but I really wanted to bring this discussion in the fold that we cannot stay away from there. And this is the one thing, like I want to, it is a good idea that having so much talent in our country, and still we have not brought India on the center stage where everybody can say that, oh, this is the place to go, this is the center to go. So we still have to work on that. And if we combine our talents, even the talents which are overseas, helping other institutions like Shweta and others, if they can share their experience, and internally Mr. 𝗖𝗍 and Rajdeep, all these people and the young like 𝗬𝗓 and 𝗓𝗏 and Satvik, all these people join together, I think India can go very far in this if we can work together. And perhaps this is the idea, and this was the idea of having this forum for 3 hours. It is long, but still we managed to discuss quite a lot. And I'm sure all of you will say that there are so many other things we need to cover which we did not cover. And I'm sure we can say that on behalf of organizers that this is just a beginning, and we should have more focused discussion sometimes later regularly for our discussion. So that's all from me. Thank you very much, panel. Thank you very much, audience. 𝗬𝗓, hand over to you.
Thank you so much, sir. In fact, I believe that the discussion was guided very smoothly by you and by the panelists also. And we got to see so many insights that I personally did not have despite having read this subject for so long, because it's the practical perspectives that matter. And for the practical perspectives, we have this power-packed panel, as you mentioned, and this power-packed panel has lasted for 3 hours. And I believe I can still see them wanting to answer more questions, wanting to discuss more. And it's just very, very tremendously heartwarming to see where India may be heading. I believe that this discussion may path the way for institutional reforms in India and bring out a policy wherein the ADR movement would be strengthened. And for the same, I thank all of the panelists for taking out time from their busy schedules. Of course, we know how lawyers bill per hour, and we must have taken a lot of money, if I may be very uncanny here. So I thank, with all due respect from CADR, on behalf of our Vice Chancellor, our Registrar, and our Faculty Coordinator, Mr. 𝗬𝗍 𝗂𝗏, Mr. 𝗵𝗲 𝗖𝗍, who could not join but still had agreed and had to face some family difficulty, Mr. Anubhav Sarkar, Mr. Simon Weber, Miss Smriti Ramesh, Miss Shweta Biduri, Miss Iram Majid, Mr. Rajit Chaudhary, Mr. Satvik Shekhar, and most definitely Mr. Dr. Rajesh Sharma for participating in this panel discussion and leading forward the movement of ADR in India and throughout the world. We certainly hope that your views would be the impetus for change, and we thank you once again.
Thank you very much, and my apology to panels if during the discussion if I have made any comment which hurt you in any way. It's not just a disclaimer, it is coming from my heart. You are all very expert. I just did my job, so doing that. So if I have done anything wrong, please apologize. Forgive me for that. Okay. So thank you very much. Thank you.
Thank you.
It was perfect. I really enjoyed the discussion. Thank you.
Thank you, Dr. Sharma. It was lovely to be with everyone on Sunday morning, and have a wonderful weekend, or what's left of it. Have a good start to the week.
Thank you.
Thank you so much, everyone. It was
And
really
now
good.
we can leave,
Bye-bye.
Kushagra.
Yes, ma'am. Yes, ma'am.
Now
Perfectly
we
so.
can choose
We
leave.
can.
Yeah.
We can. And we'll hope to
Okay,
have
thank
more
you.
sessions where we can have interactions with panelists, with professionals all around. It's our way of giving back to professionals for their contribution to the ADR community, and to just sit back and talk about things that they could not otherwise in their academic capacity, because these are questions which engage the practical experiences that you all may have had in your illustrious experience and practice. I hope you all enjoyed and it was worth your time. Thank you so
But
much.
Mr. 𝗓𝗃, I must say that your endurance of sitting here for 3 hours and actively and contributing and sharing your anecdotal story and insider story of all the developments in India. And I hope you will continue there, because you are on the ground and you are the right person to really do that. And we want to feel proud of this thing when we are outside, and when from outside, 30 years I have been out helping many countries, many institutions to develop their arbitration. We set up the arbitration and ADR system in their country, and we feel very a kind of handicap that we can't do for our own country, and that is really it's really pity to say that. I can.
No,
So
you're doing everything possible from wherever, because now the arbitration is global. So your contribution is immensely valued. Thank you so much.
yeah, so make us proud, make make India the hub of arbitration. Okay.
We've been trying a lot, and
Yes,
hopefully, and we have achieved a lot in last 6 years. So
true.
maybe more. Yeah. Maybe.
That's why the people like you should be in the committee who can tell them that that's how it is done.
Yeah, I'm
Otherwise,
actively working on the mediation also bill now. So let's hope that we bring mediation also in forefront.
Very good. So thank you very much once again. Thank you. Thank you.
Thank you.
I take your leave now.
Thank you, Dr.
Thank you very
Rajesh.
much.
It's I
Thank
think
you. Take
quarter to
care.
8 in Melbourne, right? So it's quite
Yeah,
late.
that's right.
Yeah, no,
That's
please
right.
have a nice dinner, and Bon appetit. Enjoy the last evening of the weekend.
Thank you.
Thank
Take
you
care,
so
everyone.
much.
Have a
Bye-bye.
great day.
Bye-bye.
Thank you.
Bye-bye.
Bye. By the way, Kushagra, I'll want to congratulate CADR because I am an RGNUL alumnus. So I know RGNUL inside out, and CADR has been one of the most active centers in the college. So I'm really proud of that. I'm happy that 𝗓𝗵𝗲 ma'am is upping the ante with every session, every year. And so are you still studying, or have you
Yes,
graduated?
sir. So I'm in my final year, and I think we're very well organizing the CTIL workshop in January, where we'll have a
Yeah.
similar panel discussion from panelists all around the globe. So we're hoping that we can up the ante
Absolutely, we'll do it again. And next time, I think it's physical because I love to visit campus all the time. I love to meet everyone, and especially the kudos to CDR, because with every passing batch, it's very difficult to retain the motivation and pass the baton to the junior batches. But CADR has been doing that for so many years now. I'm really happy, and I really want to congratulate you and 𝗓𝗵𝗲 ma'am, and obviously
Yes, sir.
Registrar sir. He's also been pretty instrumental in that. So I'm looking forward to collaborating more and more and
It's
visiting the campus soon.
I think it's the culture that we've inculcated here, and the team that's so proficient. We have 𝗬𝗃, Kabir, Ananya, Namisha, Yuvraj, and Jugad here who joined, and Rachit also. They've inculcated this spirit of working so hard, and I think this comes out as a reward not just to them individually but to CADR in general. So we're very happy. Thank you so much.
Absolutely. No, absolutely. I'm really proud about the fact. But you're still operating remotely, right? You
Yes,
haven't
yes,
gone
yes.
to campus.
Yes, yes.
I was having
But
a
in
discussion
January,
with
we'll be in campus, most probably.
Yes. I had a word with 𝗧𝗵𝗲 ma'am actually, 𝗧𝗵𝗲 ma'am, and she said
Yes.
that probably next session, probably next semester. But yeah, great. Thank you so much. It was a
Thank you
really,
so
really
much for
nice.
joining, sir. Thank you so
I
much
mean,
for
I
your
was a
time.
little out of place because I'm not an arbitrator, but then yeah, it was really, really interesting, and
But I thought
maybe
your
something at
views
the
were well
policy.
fitting.
Well, I just feed on the fodder I get during the sessions.
Yes.
Thank you, Kushagra. Thank you,
Let's
Kabir.
hope for
Thank you,
a
everyone.
more organized workshop where you'll fit as per your opinion.
Well, whenever it's trade and investment, I'm always the first one to jump the gun, and like go
Definitely,
for
sir.
a false start. Bye bye.
Thank you so much. Have a nice day.